Please, Lordship. This item number 30, Lordship, I beg to listen, Lordship, because I supposed to find the additional affidavit. However, the petitioner yet to come, Lordship. So I pray another 2 weeks time maybe. I supposed to find the affidavit as per the last order, dated 23/06/2023.
On pre-made by the petitioner, this is matter of 2 weeks.
Lordship.
Lordship, if I may submit, Your Lordship, if the matter comes after 3 weeks, Your Lordship, because last week I'll not be out of station.
3 weeks.
Lordship.
Obliged.
Please, Lordship.
Please, my lord. My lord, item number 38. I was supposed to file my written arguments. Lordship, I am praying for a week's time. Number 38. Matter has been heard. I was to file my written arguments. My lord, I am just praying for a week's time further.
On pre-made by the petitioner, this is matter of 1 week.
Lordship, we have already prepared our written argument. Can we file it?
File it. Give a copy to him.
Obliged.
Your Lordship, I beg to mention item number 9 to 15, joint prayer, Your Lordship. If this matter may be taken up after 2 minutes.
You are for?
And for the respondent number 4 and 5, Your Lordship.
Is that school matter?
Yes, Lordship. Your Lordship.
Connected with this Logayur matter?
Lordship, you are the petitioner.
Yes, any objection?
Lordship.
Your respondent?
Respondent number 4 and 5, Your Lordship. This one Maqbul Hussain and this one 34.
This is Your Lordship.
Yes.
Lordship, in this item number 34, 35, 36, what happened? They made a submission last time, Your Lordship. If Lordship will, can you recall?
Just we are in item number 9 to 15 first. Is the
Your Lordship, yes, is connected with item 34,
Yes,
35, 36, Your Lordship. Just to...
so since they are seeking time,
Your Lordship.
how long?
2 weeks, Your Lordship.
Then Lordship, because from 25th to 20, I'll be out of station. So Lordship,
3 weeks.
3 weeks, Your Lordship. Highly apply, Your Lordship.
On pre-made by the respondent 4 and 5.
4 and 5.
Not objected to by the petitioner and the other respondents. Matter is adjourned. List is seen after 3 weeks.
3 weeks. Highly apply, Your Lordship.
Your Lordship, I beg to mention item number 29. If this matter may be taken up after 2 weeks, Your Lordship.
No objection. 29, right?
Hearing has not commenced.
No, Your Lordship.
2017 matter.
Your Lordship.
It's a 2017 matter
Your Lordship.
that land acquisition matter.
Land acquisition, Your Lordship.
On pre-made by the petitioner. Matter is adjourned. List is seen after 2 weeks.
Much obliged, Your Lordship.
Your Lordship, can I mention item number 37?
37.
37, item 37.
You are for?
Respondent. Respondent.
Respondent.
My lord.
On pre-made by the petitioner.
Respondent, my lord.
Sorry, respondent. Not objected to by petitioner. List is matter after 2 weeks.
Please, Your Lordship. Lordship, I beg to make a mention on item 31, Your Lordship.
21.
31, Your Lordship.
You are for?
For the petitioner, Your Lordship.
And you are?
State.
State.
State, Your Worship.
On pre-made by the petitioner. This is matter after 3 weeks.
Simply prayer for item 33, Your Lordship.
33, why are we dealing this matter?
Exactly. This matter was heard again and again. This is a matter of disputed question of facts. And more so here, the right person would be the
Only,
secretary.
see, the only issue the court has to look at is whether review review will lie, whether there are questions of disputed question of facts or law.
Yes. That apart also that the main person is the party will be the secretary. On the earlier round of litigation, secretary was made a party of the school. He was the one who allegedly have issued 2 certificates. He has not made a party to the second round of litigation. That is also there.
Yeah, that is for the parties to agit. The matter has been heard. Now we are only under review.
Yes.
If there are certain material facts which has escaped the attention of the court, or points of law which has not been placed, that would be looked into. But then it should not take long for this. On premier petitioner, not objected to by respondents. List this matter after 1 week. So 1 week.
Daily costless item number 1.
May it please your lordship, before my friends start, your lordship, this is a POXO, your lordship. It appears that the informant has not been arraigned as a
Yes.
party, your lordship. You'll have to correct
This is-
the...
Lordship, this is a petition which I filed, the multiple reliefs. Here the 2 cases were registered by the police in Killarney police stations. One is 64 and 65. Then my client was proceeding towards Shillong to appear in one of the NDPS case number 9, pending in the court of Special Judge Shillong. So she was intercepted and by the police of Killarney, and they have checked, they didn't find anything, no drugs recovered from her. Afterwards, she was implicated in the 2 pending cases. Now, what is the allegation against me? The allegation against me is the conspiracy only, that you have conspired. They took some mobile, they said you are in touch with those accused already arrested in the 2 cases from the Manipur. But the mobile handset is not mine, it's somebody else, belongs to somebody else. The police has given the name of the person of the owner of the mobile handset and the SIM number registered in their name. Then we move in bail applications several times, rejected. Then charge sheet filed hurriedly, Lordship, without official report. That time also we filed an application saying that charge sheet filed without official report, incomplete charge sheet. And the court rejected on the ground, citing the reasons, not decided the case on as per the law, but different grounds. Now problem is that, Lordship, the case FSL report is not filed and the case is proceeding. Now my right to speedy trial for the case is violated, and the charges for which I was charged for section 29, there is no evidence at all in this case. So I have some prayers I have made by way of these revisions, whether the accused person can be released temporarily or on permanent bail. Because Supreme Court is coming recently, in many cases, he said, section 37 is a provision, is a very strict provisions. In one of the recent cases also, it violates the Article 21 and 22.
If the incarceration is for a long period.
Prolong. But in this case, Lordship, the trial is not at all proceeding. Trial is not at proceeding. Even till today, the trial has not commenced.
Why have you come under 482? You're seeking
482 just to secure the justice,
bail.
the ends of justice, the ends of justice.
What is your prayer actually?
My prayer, Lordship,
Is it for quashing of the proceedings?
proceeding also is there, yes. Lordship, the prayer I'm just reading it. Prayer starts, number 3, direct the trial court not to keep the trial of the case on hold only because of non-submission of FSL report or any other reasons, while the speedy trial is fundamental right, implicit in the guarantee of the Constitution and personal liberty enshrined in Article 21 of the Constitution. Number 4, the accused is entitled to be released on bail, hereafter referred to as default bail. Because that is also one of the issues to be decided by this court, whether for not filing a complete charge sheet such as FSL report, etc. To pass an order for speedy trial against the accused person while non-commencement of trial as yet after filing charge sheet is violation of Article 21 of the Constitution of India, and the accused is deprived of right to speedy trial. To pass an order setting the accused person at liberty either on regular or temporary basis on the ground of incomplete charge sheet or delay in commencement of trial or on merit of the case. Number 6, examine the records of criminal NDPS case number 9 of 2022 arising of Kheleria PS case number so-and-so, under the section 21 and quash the proceeding against the accused person above named, since the arrest of the accused person in the said 2 cases are unwarranted, unconstitutional, based on a very weak evidence and no evidence. So this is my prayer. Even I am asking for the quashing. Because the charge sheet is filed, I have enclosed a copy of charge sheet. I do not know what evidence they have collected against me. They can establish this conspiracy against me that I have conspired for supplying of the contrabands.
Charges have been framed?
Not yet, Lordship. Not even trial commence, saying that since the FSL report has not been filed, trial cannot be commenced.
So the court is waiting for the supplementary charge sheet?
Supplementary charge sheet. So in the meantime, I have filed a bail application.
You could, where have you filed a bail application?
Clear.
Then you pursue that.
No, we are pursuing. But
as far as the case is, I mean the trial is concerned,
no,
this court cannot short circuit the process.
What Lordship is saying?
It has not even commenced. Trial has not commenced. No irregularity is there.
No, Lordship, we are asking for the
question of
quashing of
ends
charge.
of justice is only with regard to your liberty, that you are entitled to under as per Article 21. Yes. File a proper application.
One of the judgment
you have submitted that you have filed an application.
Rejected.
For grant of bail.
Rejected. All 4 applications rejected. Not a very good grounds, because section 37 has to be.
At best, you can, if you come before this court, you could have come before under section 439 seeking bail, but not for quashing.
No, Lordship. In this case, I just want to place the evidence before Lordship. Even in the case charge sheet is filed, the Supreme Court has said even if the charge sheet is filed, in that case also the court under 482 can examine the matters on records and can decide the matters. So here the first question is the trial is not proceedings, still they are waiting for FSLs, charges are not framed, trial yet to commence. So these are the grounds we have taken up before this court. Even one of the ground, Lordship, we have taken, if Lordship may decide the case, so non-filing of charge sheet, whether it is an incomplete charge sheet, whether I am entitled to get the default bail or not.
Oh, that matters before the Supreme Court and before a larger bench.
Larger bench.
Once that matter has not yet been decided, so this court has to wait for the outcome.
So being a lady, Lordship, that she has been, even after filing charge sheet, the trial is not commencing. Even till today, the
How
record.
long has she been in custody?
She is custody right from 27/10/2022. And some of the accused person who have been there in the sunshine from the June. So at least if the trial proceeded, we may understand that some progress is there in the trial. For that reason, we have invoked the jurisdiction of this honorable court. The right to speedy trial. We have a judgment, Supreme Court judgment, Lordship.
It's always there. Right to speedy trial is always it is always present in every proceedings.
But Lordship, in the event, if the trial is not proceeding for any reasons, the bail also can be considered. As per the judgment of until.
What is the last order of the court?
Last of the order of the court. FSL, even the.
No, what is the last order?
Yes, I'm coming to the last order. 85 and 84 and 85, this is the order. In two cases, 84, he said, accused so-and-so produce CFSL report from Assam, FSL report on Shillong are yet to receive. No report from IO. Issue notice to the IO of this case to pursue the CFSL and FSL report and produce it at the earliest. Meanwhile, keep on adjourning the case only on this ground only. These are the only ground the cases are being adjourned. Similarly, here also, accused person remand back, issue notice to the IO to pursue with the pending FSL report, submit the same at the earliest. So each and every date, so even it violates 309, because when the person is produced from the jail, at least there must be some trial. It should be day-to-day trial. But the court cannot simply adjourn the case on the ground that FSL report is not submitted. So charge sheet filed long back in the month of many months when the charge sheet was filed. So Lordship, some interference is required by this court for such a situation.
Yes, the procedure.
Please, Lordship. My Lord, my preliminary objection with regard to the locus of the petition, it's a 482 application, not a bail application. Now, petitioner is not an accused here. How a 482 application can be filed by a stranger? For bail application, I understand there is provision. Now, that is what my thing. Now, my Lord, coming to this thing, what my learned friend has gone, it's not regret. Kindly come to the last orders, my Lord, that has been pointed out. Page 84, my Lord.
Yes.
My learned friend is taken out, my Lord. He has not last part, the fixed 12/7 for production. Now, what happened on 12/7, we do not know.
No, 12/7 is here. 12/7 I just took out from the.
My Lord, so I am going by what is there in the record, my Lord.
No,
my learned friend is
because after 12.
Now, kindly come to page 85, my Lordship, my Lord. Lordship, I can read the whole order, my Lord. This is a small order, but then just relevant part will be the third or fourth paragraph from the last, my Lord.
Please.
Shall I read the whole part, my Lord?
The only relevant part.
Relevant part, my Lord. The accused Simoti Kimnei Khoi Khongsai, my Lord, this is the accused, concerned, my Lord, is produced today via VC from Joy prison, and she did not make any complaint on being asked about her health. Her defense Simoti Kechisa is absent. Kindly see, my Lord. Landed PPC so-and-so is present. All parties receive copy of FSL report today, but since the FSL report on the seized mobile is yet to be received, hence some defense prayed to argue before charges after receiving the pending FSL report. And the next date is, my Lord, 19th, tomorrow. Now, my Lord, this part is given me. Now, they are themselves absent.
No, Lordship.
My Lord, they are not doing it. They are trying, my Lord. They are not pursuing it sincerely, trying to attribute the fault on others, my Lord.
Lordship, that is not precise here. We are
my Lord,
trying
he
to.
cannot at least argue against, if any wrong is recorded in the court order, my Lord, That is to be raised before that court, my lord. They cannot argue on that. My lord. There is apex court judgment.
Lordship, we are trying through the VC to contact and to argue. So since the case is not fixed for argument before charge, once the case is fixed for argument before charge, then I will stand and I'll argue the argument before charge. See, but
Mr. Kursi, even for appearance, you can always appear through VC.
just what Lordship, they are not giving. See, but we cannot complain against the court. We are asking them to connect us with the VC,
So no link was given.
but that also not provided.
Could be because
We are trying our level best.
there could be some
Only
network
one or
problem
two
or
occasions.
whatever.
Only one or two occasions they given a chance to appear on VC. Thereafter, never. Last time also my junior connected, waited till 5 o'clock. They did not provide the VC. So that is also our problem.
What Mr. Purisi, Learned Counsel for the petitioner. Also heard Mr. B. Varshchaji, Learned AAG for the state respondent. The petitioner has approached this court on behalf of an accused person who is detained in custody in connection with
Okay, sir.
criminal NDPS case number 9 of 2022. In both cases, she is accused.
This is Lordship. Criminal NDPS case number not 9, Lordship. It is
Is it 9 and 11 or
9 and 11. 9 and 11.
9 of 2022, and also in another case being criminal NDPS case number 11 of 2022. The grievance of the petitioner is that though the accused was is in custody for a very long time, since the month of September,
October 27.
October 2022, the trial before the trial court has not proceeded in the manner it should have, even though the charge sheet was filed. But all the same, the complete charge sheet has not yet been filed, in as much as the court is still waiting for the FSL report to be filed by the IO before commencing with the full-fledged trial. The delay in the proceedings has violated the liberty of the accused and is therefore in infringement of the provision of Article 21, submits the Learned Counsel, and under the circumstances, it would be but prudent for the trial court to proceed with the proceedings, and in the absence and in the inability to do so, the accused is entitled to be released on bail, even on default bail. It is because of these circumstances so evident in the proceeding wherein the trial of the proceedings before against the accused person and other co-accused have been hampered and delayed. The petitioner has submitted that the proceeding as a whole may be quashed. And the accused person to be set at liberty. Mr. Per contra, Mr. The learned AG has submitted that the first objection is with regard to the locus of the petitioner, who is not at all involved in the matter, when in fact for an application under section 482, the aggrieved person or the concerned person should have been the one to approach this court. Even though the accused may be in custody, there is no bar for filing of an appropriate application under the appropriate provisions of law before this court or any competent court for that matter. The learned AG has also referred to the order dated 5/7/2023 passed by the learned trial court. Such order being annexed at page as annexure 12 at page 85 of this petition.
I'm referring to page 84 also, same ground, my lord. Here also defense counsel have sent, my lord.
84 and 85, huh? At annexure 11 and 12 respectively, being annexure 11 and 12 respectively, to say that when the matter was called up before the court, the defense counsel was not available, and as such, the accused or the petitioner for that matter cannot come before this court to say that the accused is prejudiced in the matter. It is also submitted that the trial is proceeding in its usual pace, in its usual course, and by the order dated 5/7/2023 bracket supra, the next date fixed is 19/7/2023 for production and submission of pending FSL report. It is therefore prayed that this petition is devoid of merit and the same is liable to be dismissed. This court, upon hearing the parties and on perusal of the petition, is without going to the detailed merits of the case, would observe that the grievance of the petitioner or the accused person for that matter, or the accused person, is primarily with regard to the slow pace of the proceeding before the trial court, as well as the irregularity in the proceeding, in as much as though the charge sheet was filed, the complete charge sheet has not yet been filed, pending the report of the FSL, pending the production of the FSL report, and that the court and that the proceedings is stalled at this stage to the detriment of the accused person in question. On further observation, this court, particularly on going through the relevant orders at page 84 and 85 of this petition, would have observed that the trial court has done nothing out of the ordinary, but has proceeded as per procedure. Failure to file the FSL report in time would not be a valid ground for the proceedings to be quashed. The incarceration of the accused in custody, even if it is for a long period, would also not be a ground for quashing of the proceedings. It would be open for the accused person to prefer an application for bail if so advised. Therefore, this court is of the considered opinion that this application is devoid of merit. The same is liable to be dismissed, and is accordingly done so here. Before parting, this court would request the trial court to proceed with the matter in accordance with law, and to ensure that there is no unnecessary delay in the proceedings. With the above,
one more, it may be provided the link of PC. That is very important.
Sure, one paragraph. The learned counsel for the petitioner has also submitted that it is not the fault of the defense counsel that she was not present when the matter was called up before the trial court on the set dates, that is 28/6/2023 and 5/7/2023. The fact is that there was no link provided for appearance through the virtual mode. In this connection, the trial court or the authorities concerned is requested to ensure connectivity, proper connectivity, to enable the parties to appear for the court through the virtual mode, through the virtual mode.
The order says the accused appeared through VC, my lord.
No,
VC, you see, from jail there's a connection. But from outside,
yes,
except the defense goes.
Link, my lord. No, jail also cannot connect.
Once or twice we are given chance, but afterward not at all.
You see, Mr. Krushi, we can understand. If it is Clearyard or even William Nagar or some other places, connectivity is very bad. Sometimes it's there, sometimes it's not there.
But here it is available in the Clearyard I have seen.
If it is available, then there should have been connection. But you can always make a call.
We made a call, Lord, but how to allegation? We made a call, we requested the bench assistant, then
the court
even there is not given.
Court should have taken note of that.
Yes, yes.
Item number 4.
In this Lordship, filed an affidavit stating that the service of notice upon the respondent number 2 is complete, Lordship.
Who is respondent to?
Respondent number 2. Affidavit was filed on 14/7.
No, who is respondent to?
Secretary NMC.
Okay.
I'll appear for them also.
Initially, Mr. Lordship, I take serious objection to Learned DSG's changing his stance. Initially, he had not appeared for him. Then subsequently, it was all recorded, Lordship. And finally, he had got submission that notice be sought upon the respondent number 2, and then the steps has been taken. So he's changing.
I don't understand, my lord. Now I've received, after he took steps, my lord, the medical commission has contacted me, my lord.
It's a question of instructions.
Lordship, but
if he has received instructions,
if he has a problem in me appearing, my lord, I'll inform them that he doesn't want me to appear in this matter. But that's very strange objection.
Yes, Lordship, at some point of time it will be reflecting that how DSG will be appearing for the Ningrims, at the same time for the Union of India, at the same time for the private respondents.
My lord, he can file an objection, my lord. Let this issue be decided then, whether I can appear or not, my lord.
As of now, today, Lordship, if he is appearing, then I will not say anything. But it is really very sad, Lordship, that he had changed his stance twice, thrice.
So at the time of argument, when you place your
yes,
objection,
that I will.
We'll see.
Definitely.
You back it up by relevant authorities.
He took steps, my lord. They received notice, then they called me that you appear in the matter.
Okay.
So service of notice upon the respondent number 2 is complete.
I don't really see what is the problem in that.
So, what about rejoinder?
Rejoinder, Lordship, I will require 3 weeks time. I have almost completed, Lordship, but there are some corrections that are required to be made.
Right. And you will be filing your counter?
Sometime, 3 weeks time.
The counsel for the petitioner has submitted that the service of notice on the respondent 2 is complete. This, Ms. Dr. N. Musica, Director DSGI, has submitted that he is instructed to appear on behalf of the respondent number 2 and has sought for some time to file the counter affidavit in this regard. The letter counsel for the petitioner has also submitted that he may be allowed some more time to file or rejoin the affidavit to the counter affidavit filed by the other respondents who have since filed their counter affidavit on preambit less this matter of the
3 weeks, Lordship.
3 weeks.
Item number 6.
In item number 6 also, I am praying for 3 weeks time, Lordship, to file rejoinder.
This is only for filing of rejoinder?
Not only for rejoinder, but also for the affidavit in opposition by respondent number 9, 10 and 11.
Who is appearing for them?
I appear for them. They instructed me to appear, my lord. Because these are
private respondents from
yes.
One is from AIMS.
So you have to file their counter then.
I've not been able to file this because 2 are from AIMS Raipur, my lord. They have instructed, and 1 is from Mizoram, my lord. Joram Medical College.
Joram Medical College.
Some more time, my lord.
So 3 weeks, Lordship.
Dr. N. Musica, at DSGI, has submitted that he may be allowed some more time to file the counter affidavit as regard the respondents number 9, 2, 11, 9, 10, 11 and 11 respectively. On preambit, same is allowed, less this matter up to 3 weeks.
Item number 7.
May I please, Your Lordship? In this matter, the conducting counsel is from Guwahati, so I have been instructed to appear on behalf of the conducting counsel. The thing is that he is not keeping well.
What about the settlement?
Well, we've already sent our agreement via email. I believe they have received it. Now, today my learned friend says that the conducting counsel is not really seeking some time. Well, if that is the case, my lord, a week's time may be given.
What about you? I mean, is there any instruction as to whether the...
I have told that they agree to the settlement. However, my agreement has been drafted and sent via email. So they acknowledge the fact that they've received a copy of the agreement, but he today is seeking some time, and in a week's time may be granted. I have no objection to that.
Since he's under bed rest, Your Honor, a possible 2 weeks time.
2 weeks is fine, as long as the matters can be settled.
But in the meantime, pursue the
I will pursue
settlement
it.
part
I will. I'll speak to him.
on prayer made by the petitioner. This is matter of 2 weeks.
Obliged.
Item number 8.
May it please Your Lordship. Lordship, in this matter, this is a quashing application, Your Lordship. If Your Lordship kindly see the cause title, the informant as well as the accused, they are filed this application jointly, Your Lordship. So since it's a matter of compromise, Your Lordship, and in view of the fact that both the parties, they have filed it jointly, Your Lordship, in my humble and respectful submission, Your Lordship, the learned trial court may be directed to record the compromise and forward it to the court, Your Lordship.
Compromise has been.
Lordship, it appears, it appears.
You have annexed the
I have an X, Your Lordship. Next to
at page 15, Your Lordship.
POCSO matter.
No,
No,
it
this
is under section
normal
365.
penal code, Your Lordship.
Okay.
At page 15, Your Lordship.
Section?
Section 365 and 420.
Kindly come to page 15, Your Lordship, of the application. Because this is a compromise letter with not in a stamp paper, not in a notarized also, Your Lordship. It is
Yes.
a simple application, a simple compromise, Your Lordship. Then Lordship kindly come to page 2. Then
What is just read out what is there. in 15.
Lordship, this compromise deed is signed between Miss Rosemary Macri and Miss Pila. Rosemary is the accused and Miss Pila Klein is the informant, Your Lordship. Putting their signature herein below with regard to the FIR dated so and so. The settlement is done in good faith with the intervention of the family members and well-wishers. It is clear accepted the fact by both the parties that the cause basically is nothing but pure misunderstanding and lack of communication between the two parties, complainant and accused person. The fact is that Miss so and so was traveling for the first time outside the state and by train, so on the way a group of third gender entered the compartment and asked money from the complainant, but since she could not understand the language, the group started shouting with the very abusive language on which the accused person is also the victim herself. And during the day, many men entered the compartment and speak in a very rustic manner. Therefore, such circumstances created fear and sense of insecurity to the complainant, which then made her to run away from that train. And today it is agreed by both the parties about the mentioned circumstances to be true and ready to reconcile with each other. Put this understanding to an end in good faith. All issues of conflict or misunderstanding are hereby resolved once and for all by this deed of compromise, and out of full consciousness, in good faith and of mind and body together, both the parties decided to put an end all differences and to continue their relationship amicably, and this deed of compromise shall stand absolute from our side, signing together on this so and so. Lordship, they not in a stamp paper and it's not notarized. Then Lordship kindly come to page 2, the name of the parties. This is a joint application, Your Lordship. In fact, Your Lordship, the petitioner number 2 ought to have been read as a respondent, so that she can come and have a say. So in that.
Anyway, since
My submission is not, I'm doubting the compromise, Your Lordship. I'm doubting their intention to settle, Your Lordship. What I'm submitting before Your Lordship is that these are the joint applicants, Your Lordship. So in the fairness of thing, in my humble and respectful submission, Your Lordship, if the learned trial could be directed to record and forward it, the proceeding of be forwarded to this court.
Record what?
The compromise, Your Lordship. It is not in,
I have
in stamp paper also, Your Lordship. It's not notarized also, Your Lordship.
Your Lordship, I make quickly 2 points. Firstly, when both the complainant and the accused person can file the joint complaint together, as many other in the past has been
That
done.
of course.
And then the second, with regard to compromise, it is not necessary that it should be recorded also in court on the stamp paper. But if the court asks, we are ready to do so from our side.
Anyway, looking to the facts and circumstances of the case, court would be inclined to, to accept the bona fide of the parties.
Lordship should not doubt my submission, Your Lordship. That I'm doubting the deed of settlement. What I'm submitting before Your Lordship is that it is not notarized, it is not stamped, Your Lordship. So the proper proceeding has not been followed, Your Lordship, in that for that matter. Because I will not stand on the way, Your Lordship. The state will not stand on the way.
What is the stage of the case?
It's CC,
Your Lordship. It has been transferred from the Court of Chief Judicial Magistrate to the District Council Court. It's pending, Your Lordship.
But Mr. excuse me, PA Document, Learned Counsel for the petitioner. Also heard Mr. N.D. Shulai, Learned AG for the state respondent petitioner. So, according to the petitioner, according to the petitioners, an FIR was lodged by the petitioner number 2 before the officer in charge, Nongpoh Police Station, Triboi District. The contents of the FIR would show that the informant and the complainant, the informant and the accused, who is the petitioner number 1 herein, have travelled together by train. Oh, this is not what it says in the FIR. Okay, by train from Guwahati towards Uttar Pradesh. In course of the journey, an incident occurred wherein some persons accosted the complainant, oblique petitioner number 2, and out of fear she alighted from the train and returned home to where is she staying?
Stay in Nongpoh.
Return home to Nongpoh. On reaching Nongpoh, assuming that the petitioner number 1 is involved in the said incident, wherein she was almost assaulted by the said persons, the FIR was lodged. In course of time, On receipt of the said FIR, the police registered a criminal case being Nongpo PS case number 885 of 2014 under sections 365/420 IPC. At present, the stage of the case is for consideration of charges. In the meantime, the complainant and the accused, having realized that it was on account of a misunderstanding of the situation that has led to the filing of the said FIR, good sense prevailed and so as not to cause any inconvenience or prejudice to the parties, particularly the petitioner number 1 accused, the petitioner number 1 and the petitioner number 2 respectively has come to a compromise and understanding between them and to this effect has executed a compromise letter dated 6 June 2023, wherein it is stated that on account of misunderstanding, the said FIR was lodged and that no prejudice will be caused to either of the parties if the criminal trial and proceedings be quashed. Hence this petition. Hence this application. Mr. Indishulai, Learned Counsel, Learned AAG, appearing for the state respondent, has submitted that no strong objection is made to the prayer of the petitioners. However, on perusal of the records and the said compromise letter annexed at page 15 of this petition, it is seen that the same has been made on a plain paper without being authenticated or notarized. And to this extent, the learned AG has submitted that though the prayer of the petitioners may be allowed, however, the matter may be remanded to the trial court with a direction to cause the petitioners herein to execute a proper compromise deed, and thereafter the matter to be disposed of accordingly at that level. This court, on consideration of the submission made, firstly would note that this application has been filed on affidavit sworn by the petitioner number 1. Nothing is said in the affidavit that the said deponent has sworn the affidavit on her behalf as well as on behalf of the petitioner number 2. Prima facie, it appears that the petition is defective on this count, inasmuch as when a affirmance and assertion has been made in the petition, it would be incumbent for all the parties concerned to attest to the truthfulness of the same in the affidavit. It may also be the case that the parties would entrust or allow the affidavit to be signed on their behalf. However, this fact has also to be shown in the body of the affidavit, which is absent in this case.
Lordship, may I just comment on this affidavit that Para 2 it said that I am one of the petitioners in the instant petition and duly authorized by the other petitioner to swear this affidavit.
Duly authorized, sorry.
Yeah. Lordship.
Can I have to get my glass corrected. Power has diminished. Tapi nak betul tak? Kemudian tu kau tapi juga last paragraph itu. Tak pom nak tu. Pom nak tu ke huruf paragraph. Cuai ke tu. Keturuk pom nak tu. Cuai ke tu. Next one. In answer to this contention, this court on perusal of the petition would notice that at para 6 of the same, it is noted that the petitioners have, it is noted as follows. Quote you to para 6. Next. It is also to be reminded that the petition has been filed with an affidavit sworn by the petitioner number 1, who has also averred that she is duly authorized by the petitioner number 2 to swear the same on her behalf, on her own and the petitioner's number 2's behalf. And as such, when the averments have been confirmed by an affidavit, only in the case of an apparent attempt to mislead the court or to swear an affidavit on facts which are not correct, the court would accept the same as being made bona fide. Accordingly, the contention of the submission of the learned AAG on this count is not accepted. On an overall consideration of the case of the parties, since the matter has been resolved at their personal level and there is no direct implication as far as the society's interest is concerned, the offence are also not heinous or very severe and serious in nature. The parties, if they have come to a compromise, the same has to be accepted by the court. And the same is liable to be accepted by the court. Time and again, this court, in similar situated circumstances and cases, have referred to relevant authorities and the oft-repeated case of Narendra Singh versus State of Punjab, 2004-14, 6 SEC 466 at para 29, kita para 29.1234 would be relevant to the facts and circumstances herein. Accordingly, in view of the above, this petition is allowed. The proceedings, the FIR dated
29/05/2014.
29/5/2014, and the proceedings in Nongpo PS case number 88/5 of 2014 are hereby.
GR case number 768.
GR case too. GR case is also there.
168 is the
and the
same.
subsequent GR case number 168 of 2014 pending before the court of the which court?
District Council, subordinate district council court.
Before the subordinate district council court Nongpo are hereby quashed.
Also to be discharged from oral bail executed.
The accused person is discharged from all liabilities as regard the case.
Obliged.
Petition disposal.
Much obliged.
Item number 16.
Your Lordship, these matters now this ROC has been transferred and new ROC is supposed to join. So I put the spanners to give the compounding report.
Your Lordship, my instruction is that the application for compounding has already been filed.
Now already fund it is earlier given. So in the meantime, ROC has been transferred and new ROC is joined, but he's just joined on
If only an observation be made that the ROC to expedite the matter.
If ROC join and then afterwards I'll request him new ROC.
Mr. P. Nongri, counsel for the petitioner, has submitted that the petition seeking compounding of the matter has been filed before the competent authority. However, Mr. Ardemna and CGC has submitted that the ROC registers of company.
Register of companies.
The Register of Companies under bracket ROC has been transferred and a new incumbent has taken over, and as such it would take some time for the new incumbent to be apprised of the matter, for which some time is prayed for. It is to be reminded that this matter has been lingering on this point for quite some time. The parties are unwilling to pursue with the merits of the case in the hope that the matter would be solved at a different level or forum. Be that as it may, the court, while considering the prayer made, would impress upon the respondent, respondent what any particular, who is the
Register company.
Registrar
company.
respondent register of company to expedite the matter at the earliest, preferably within the next date fixed for a report in this matter before the court. As prayed for, release this matter after 3 weeks. I think within 3 weeks the matter can be solved.
And that is in 16, 17, 18. In respect of 19 and 20 and 21, those cost audit report for 14, 15 has already been filed way back, long time ago.
Let it be after 20 because my instruction was last question, all of them has filed.
No, as far as this is for 16,
17, 18.
17, 18.
This is MECL.
Okay.
And 19, 20, 21, the cost audit report, which they are alleging that we have not filed for the year 14, 15, that has filed on that particular year itself.
So what do we do now?
Because these matters are tagged together, Lordship.
Let me have the instruction receipt because last question says all the matters. Some cases
because I have those documents that it has been filed.
That was the part of the complaint.
Yes, yes.
That it was not filed.
The allegations was that 13-14. We have come before this court saying that for the financial year 13-14, that particular law, section 148 of the Companies Act, that was not enforced at that point of time. But they came up with an affidavit saying that it is a mistake on their part. It should be 14-15.
But actually, it has been filed. So you seek instructions? Can I have 19 more? But you are not here, Mr. Devnath. Are you? I think Mr. D is here.
Opuda is there, but
Where's?
He can always take instruction also.
He's not here. Okay, we'll not complicate the matter.
Yes. We'll keep it after 3 weeks.
You will keep it after 2 weeks, and you get instructions.
Yes.
If at all is to be pursued, then we'll look at it, at that point of time.
Obliged.
Item number 22.
May it please your lordship.
Yes. Please.
Lordship, I'll be addressing your lordship with regard to item number 22 only now, not the other connected matters.
Fine. So this is
Surajit
WPC 44 of 2015.
Lordship.
Surajit Datta.
Lordship. Lordship, the factual matrix of this case is that, Lordship, I was initially appointed as a proofreader, Lordship, which happens to be a non-teaching post in Nehu. I was posted on 22/8/89.
(22/8).
8/89.
Proofreader.
As a proofreader, Lordship.
Yes.
Your Lordship will kindly note that in the meantime, I have taken voluntary retirement last year, Your Lordship.
Okay.
Now, this case pertains to the issue of financial upgradations in a post which otherwise has no promotional avenues. Lordship, this is a post, Lordship will kindly appreciate, has no scope for any promotion. And as such, to compensate for that, Your Lordship, there is this financial upgradations which are given as incentives to the incumbent. In this case, Lordship, we would be concerned with 3 upgradations, which is usually given. The first one is called OTUM, Your Lordship, OTUM, that is in short for one-time upward movement in Nehu, which can be availed, Your Lordship, after being in service for 8 years in a particular grade. Now, the other 2 which would be of consequence here, Your Lordship, is ACP.
So autumn would implies a financial upgradation.
Which is given by the university. But in this case, of course, it is not been given. That is, I'll come to that. I'm just saying that what are the
commensurate with the scale of the next higher post, if at all there is.
No, Lordship, if a person has been in service for 8 years in a particular post, he is entitled to this financial upgradation. As per Nehu.
But what exactly is that?
Financial upgradation.
Yes, how is to be worked out?
Lordship, the pay scale, Lordship.
Pay scale.
Yes, Your Lordship. But this is not so much of consequence in this case. But of course, I'm just laying out what are the different upgradations which will be we'll be dealing with in this instant matter. Of consequence is ACP, which is Assured Career Progression Scheme, Your Lordship, which provides that after 12 years and 24 years of being in service, the first upgradation would be availed after 12 years and the second one after 24 years, Your Lordship. And the third is MACP, that is Modified Assured career progression scheme. Now, this says that after 10 years, 20 years, and 30 years, an incumbent is entitled to these upgradations. Now, my limited case, Your Lordship, actually it is a very simple matter. My limited case, Your Lordship, is that I have joined, as I have said, as a proofreader in the year 22/8/89, and I have taken voluntary retirement last year, which, Your Lordship, makes it roughly 33 years. 89, 99, 2009, 19, roughly 33 years. Admittedly, Lordship, no promotion. There is no scope for promotion. So, I should have got, Your Lordship, in the natural scheme of things, 3 financial upgradations. My limited case, Your Lordship, is that I have got only 1 financial upgradation, whereas Nehu claims that I have been provided with 2 upgradations. Regarding the 3rd upgradation, they do not deny that I am entitled to it, but they say since the matter is sub judice, that's why it has not been given to me. So the only question in my humble submission, which Your Lordship will decide, is whether I have got 2 upgradations or I have got 1 upgradation. My grievance, Your Lordship, is that I have got only 1 upgradation and I am entitled to the other 2. That in brief is my case, Your Lordship. Now, in 89, Your Lordship, he joined in a scale, because the scales would be of relevance, Your Lordship. So, if Your Lordship will kindly note.
Yes.
When I joined, Your Lordship, I was receiving a scale of rupees 1200, 2040. 1200, 2040.
Yes.
Lordship, this subsequently it was immediately modified in a day or two. This was on 24/1/89. On 7/4/89, they have corrected and made it into 1320, 2040.
So in 13?
1320.
No, no. When was it?
This is on 7/4/89.
Okay. 7/4/89.
Lordship.
But you joined in August.
Sorry, Lordship, I joined on 24/1/89. So sorry, that date is wrong, Your Lordship.
20?
24/1/89.
Okay.
And on 7/4, Your Lordship, this is given as 1320, 2040.
Yes. Please.
Lordship. Now, thereafter, Your Lordship, the the 5th CPC came into being, Your Lordship. And as per that, the pay scales have been revised. Now, as per the revised pay scale, Your Lordship, I am entitled to get 5,500, 9,000.
Yes.
Now, this revised pay scale, Your Lordship, as per the, we had placed it earlier also, Your Lordship had seen, it is also in one of our affidavits, Your Lordship, but I am placing the book just for ready reference, Your Lordship. Your Lordship will see what has been marked, Your Lordship. That is the post of a proofreader.
Is this there? 50 Commission?
Lordship, revised pay rules of 1997.
Yes.
The relevant page, Lordship, for his ready reference we can give.
Page? You can, I think the book is here.
It might not tally, Your Lordship, the pages perhaps.
Why? You're referring to the same book? Should
Your Lordship is holding this book at page 63.
If it is the
green one.
I think
I am not having a green one, I have a different color, so might be the pages will not tell.
Lordship can look into 63 page.
60? 63?
Lordship, I have an extract of the same, so Your Lordship may also, to avoid
It's not here.
I have an extract.
Just one. I know.
So Lordship,
This is page, you said again, 73. Here it's 72.
it is 72 in this book, Your Lordship.
Okay.
The extract will show, Your Lordship, the revised pay scale for the post of proofreader, Your Lordship,
Yes.
after the 5th CPC, Your Lordship, should be 5,500,
Yes.
9,000.
Yes.
Now, if Your Lordship is pleased to turn to page 31 of my amended writ petition, Your Lordship. Page 31, Annexure 4. If Your Lordship has got it.
Yes.
That's a notification dated 29 September 1998.
Just a moment. Page 31.
Page 31, Annexure 4, Lordship. Of the amended writ.
Rantun. Oh. Yes.
Lordship, this is a notification dated 29 September 98.
Yes.
This is in pursuance of the revised pay scales recommended by the 5th Central Pay Commission. This is issued by NEHU, Your Lordship,
Yes.
showing the different pay scales after the revision.
Yes.
Now, Lordship will kindly come to column number 7.
Yes.
Lordship, it starts off with UDC stenographer, if Your Lordship has got that.
Yes, I got it.
And the one at the, in this column, the last one is proofreader, if Your Lordship will kindly see.
Yes.
Now, the revised pay scale as shown by this notification is 4,000, 6,000, Lordship. Lordship will see here what DOPT has published. It is 5,500, 9,000. But NEHU has wrongly published it as 4,000, 6,000.
Okay.
So, Lordship, because when,
Yes.
as per the 5th CPC, Central Pay Commission Revision, Your Lordship, the post of proofreader, wherever across the country, gets, the pay scale gets revised to 5,500, 9,000. So here also, Lordship, in NEHU, because this should also have come as 5,500, 9,000, but wrongly it is shown as 4,000, 6,000. So, Lordship, being aggrieved, Lordship, I have written to the authorities concerned for correction of the same. And my representation is at Annexure 33, page 5, Your Lordship.
Annexure 33.
The next one, Annexure 5, page 33, Lordship. This is my representation.
Yes.
Regarding this, Your Lordship, that it should not be 4,600, 6,000. It should be 5,500, 9,000.
Fine.
In response to that, Your Lordship, necessary corrections are made by Nehu, and I am given 5,500, 9,000 as a replacement pay scale.
Okay.
That, Lordship, will find at page 35, Annexure 6. This is dated 16/8/2001, but given with effect from 1/1/96. May I read that first para, Lordship, of this?
Yes.
In pursuance of the resolution number so-and-so dated 4/5/2001, the Vice Chancellor of the Northeastern Hill University is pleased to order that the proofreader of Nehu be granted the scale of pay of rupees 5,500, 9,000 with effect from 1/1/96.
Okay.
Lordship. So, Lordship will kindly appreciate
Yes.
that on my pointing out that there was some error and the notification of Nehu was not in consonance with the pay revision recommendation, then only this correction has been made, and whatever scale is given to all India proofreaders, I have got it, Lordship. So, Lordship, I'm laying a lot of stress on this because this is where my case hinges. This is not an upgradation. This is only a replacement pay scale. Pay scale which should have been automatically given to me. There was a mistake. I pointed out. They corrected it. So it is called a replacement pay scale.
Yes.
So I have not been given any upgradation by Nehu.
Yes.
Now, the second para of this very notification, Your Lordship will kindly see.
Yes.
The Vice Chancellor is also pleased to order that the proofreader will not be entitled to any benefit under the one upward movement scheme in view of granting the higher pay scale of 5,500, 9,000. This is where all the problem starts, Your Lordship. This is not a higher pay scale. This is a replacement pay scale. And, Lordship, what has been informed to me is that I am not entitled to autumn. Now, the date here is very relevant, Lordship. Lordship, I joined in 89. Autumn is made available after 8 years. 89, 90, 91, 92, 93, 94, 95, 95, 96, 97. Lordship, autumn should have been made available to me in 97. But here, Lordship, it has been specifically mentioned that you are not entitled. So that has not been given to me, it becomes clear, Lordship. It's not that they cannot claim that this was one upward movement or this is one upgradation you have got, so you cannot claim further upgradation. That is not the case because it's made clear by Nehu itself. So then, from where I stand, Lordship, I joined in 89 and this is issued in 2001. Lordship, 89, 99, 2001, that becomes 12 years. 2001, Lordship, I am entitled to the first upgradation under the ACP, which is made available after 12 years. Lordship, admittedly, this is not an upgradation. Lordship will kindly note that this is being made available to me with retrospective effect from 1/1/96. Now 96 is neither 8 years nor 12 years, Lordship. So they cannot say that they've given me an upgradation under autumn or they have given me an upgradation under ACP. Because in 96, your Lordship, it falls short of 8 years and 12 years both. So this Lordship is only a replacement pay scale. This cannot be termed as a upgradation, Lordship. So then when is my upgradation given is the next question, your Lordship. Now, Lordship will kindly see at page 58, Annexure 13, Lordship. Clear. Lordship, this is dated 20th December 2013. If your Lordship has got page 58, Annexure 13.
Please.
Lordship. Lordship, if I'm permitted to read this, Lordship.
Please.
Under the provision of the University Grants Commission letter number so-and-so, dated 14/7/10, as approved by the Executive Council in its 146th meeting held on 24/5/11, wide resolution number so-and-so, and in pursuance of the recommendation of the screening committee held on so-and-so, the Vice Chancellor is pleased to grant financial upgradation under the Assured Career Progression Scheme to the employees as per Annexure 1. So, Lordship, is the next page is this Annexure 1, which they are giving to me. Lordship, there's a typed copy also at page 59A.
Yes.
Lordship, my name in the first column. Then, Lordship, the designation, proofreader, because it remains the same. Scale of pay, your Lordship, initially I joined at 1200/2040 and within 3 months it was just corrected. So, this 5,500, 9,000 which they show, Lordship, is a replacement pay scale. I hope I've made myself clear, Lordship, and it's not an upgradation. So, Lordship, after that, if your Lordship kindly come to the column under scale, column number 10.
Yes.
This benefits which has been given, Lordship, that my scale has been increased to 6,500, 10,500. This is an upgradation.
Where is the scale is nothing here. Okay. Oh.
Lordship, I'll take your Lordship. I'm just saying that what they have given is, this is a financial upgradation.
Okay.
Lordship, it's written on top also, if your Lordship is pleased to note. The list showing the details of employees cadre-wise eligible for consideration of financial benefit under the ACPC scheme it should be ACP scheme in accordance with the EC resolution number so-and-so and LCRC recommendation in its 14th meeting so-and-so and subsequent resolutions adopted. So, Lordship, this is the financial upgradation which is given to me. Lordship will kindly note that the replacement pay scale was 5,500, 9,000. So, the next one in this is 6,500, 10,500, which they have given to me. But this they call it, Lordship, will kindly note, this is called SFU. In column 9, not Lordship, it is called SFU. If you under nature, what is the upgradation?
Yes.
It is called SFU, which in short is for second financial upgradation. So, Nehu is saying, Lordship, this is my second financial upgradation under ACP, and I've got the 6,500, 10,500. Now, Lordship, I can get a second only if I've been given first. Admittedly, they have not given me any first, your Lordship. That's my grievance, your Lordship. Now, the other thing of relevance is, Lordship, this upgradation, Lordship, is given on 20th December 2013 with effect from 1/1/2008.
Where is it written?
The date is under column 11, Lordship. This is effective from 2001/2008, and it is issued on 20th December 2013.
Okay.
So, Lordship will kindly note that I was entitled to my first upgradation under, if it is under ACP Lordship, 12 years. So from 89 onwards, whenever it is 12 years, it was due to me. 89, 99, 2001 Lordship, it is 12 years. So in 2001, it was due to me. The first upgradation has not been given to me, Lordship. So if at all, Lordship, this is the first upgradation which is given, which I am now taking your Lordship through, which they are calling second financial upgradation. This is my first financial upgradation, which is given only in the year 2013 with effect from 2008. It should have been from 2001. So, Lordship, if this is the first financial upgradation, then I am entitled to 2 more financial upgradations as per the MACP. Because meanwhile in 2006, MACP has replaced ACP, and then it was, Lordship, that if after every 10 years, 20 years and 30 years, the incumbent is entitled to financial upgradation. So by that logic, Lordship, in 89 I joined, so 99 should have been my first upgradation. 2009 should have been the second upgradation, and 2019 should have been the third upgradation. So that has not been given to me, Your Lordship. Now, for that, Lordship, I have represented before the authorities. But before that, Lordship, when I am saying that, Lordship, this first, when this replacement pay scale was given, 5,500, 9,000, Lordship, Nehu also agrees and admits, Lordship, that this is the core pay scale of the post of proofreader. Am I, if I'm permitted, Lordship,
Yes.
this has been annexed by them in the rejoinder. Lordship, there are several exchanges of affidavits from both sides. So if I'm permitted to place it serial, or Lordship, we have now filed an amended writ petition. Lordship will see that first, initially, an affidavit in opposition was filed by the respondents 1 to 5. Then we have filed a rejoinder. Then they have filed, if that is before your Lordship, then it will be easier for us to take your Lordship through the documents. Lordship, the first affidavit is
This
filed
is
somewhere in 6/8/15.
6/8/2015.
Yes, Your Lordship. So, in response to that, Lordship, we have filed a rejoinder affidavit.
That is on 24/11/2015.
Lordship. Yes, Your Lordship. November 2015. Yes. Now, thereafter, Your Lordship, they have filed another additional affidavit, Lordship.
Yes.
If Your Lordship has got that.
8/3/2019.
8/3/2019, Lordship. Then we have filed, Your Lordship, an affidavit in reply to that additional affidavit that is dated 20th March 19, Lordship.
Yes.
And then we have filed another additional affidavit for bringing on record subsequent events that is on 13/10/20. If Your Lordship has got that last one. 13/10/20 is before Your Lordship.
No, 13/10/20 is the order. You have filed it on 6/11/2020.
Could be, yes. It 11/20/20, Lordship. Lordship, that is before Your Lordship. So now, Lordship, I am referring to this second affidavit which we had filed in response, which is our rejoinder to the second additional affidavit.
That is?
That is dated 20th March 19, Lordship.
Yes.
In this, Your Lordship, we have brought on records the minutes of the 109th Executive EC meeting. The relevant page, Your Lordship, will find at page 18. Lordship, these are the minutes of the subcommittee constituted by the Executive Council. So it's totally their document and their findings.
Yes.
Lordship, page 18, column K. Pay scale of the proofreader, Lordship.
So this minutes of the meeting is on?
It is on Lordship, April 4th, 2001. That you'll find at page 12, Lordship.
April 4th.
Lordship.
Okay.
Now this is, Lordship, with regard to the pay scale of the proofreader, which we are concerned with, Lordship.
Yes.
Lordship, I'm reading the second part of this. Starting from the committee noticed. May I read, Lordship? The committee noticed that the University Grants Commission has not prescribed any revised payoff scale for the said post. That is the post of proofreader. Whereas the Government of India Department of Personal Public Grievances and Pension prescribed the scale of rupees 5,500, 9,000. Lordship, this is what I was referring to. This is by the DOPT. As core pay scale, Lordship. As core pay scale for the post of proofreader. The committee further felt that under the present setup, there is no promotional avenue for the proofreaders in the NEHU services. The committee thus decided that the proofreader of NEHU be placed in the scale of pay of 5,500, 9,000 with effect from 1/1/96 and be treated as core pay scale. Since there is no promotional hierarchy in the grade under the NEHU services, the proofreader cannot be granted upward movement. Lordship, this is in essence our case. NEHU themselves are saying, Lordship, that as published by DOPT, Your Lordship, for the post of proofreader, the pay scale is 5,500, 9,000. They admit this is the core pay scale, as there is no promotional avenue. Now, if this is the core pay scale, Lordship, then this scale cannot be called an upgradation at any point of time.
Yes.
Lordship, I would like to make myself clear on this and reiterate this point.
Yeah, so the core pay scale is 5,500,
9,000.
So which you had got
as a replacement pay scale.
As a replacement pay scale according to you.
Lordship. So this is not an upgradation. So then the only upgradation which has given to me, Lordship, is that 6,500, 10,500,
Yes.
which they say is the second upgradation, but which actually is my first upgradation.
Yes.
But Nehu is saying, Your Lordship, that when I got 5,500, 9,000, that was the first upgradation. They cannot at the same time say that this is your core pay scale as shown by DOPT. They themselves admit, and this is in their meeting, Your Lordship, the resolution taken. So if admittedly this is a core pay scale, so the next pay scale, Lordship, is 6,500, 10,000, which they gave to me only in 2013 with effect from 2008. So that is the first upgradation I have ever got. After that, Lordship, as I said, I have taken voluntary retirement last year after 33 years of service with only that upgradation. Two other upgradations are due to me. That's my limited case, Your Lordship. So, Lordship, of course, to bring home this point from both sides, we have exchanged a lot of affidavits. So, if Your Lordship permits me, I can just take through a few of the documents, or if my learned friend wants to respond to this aspect, then I can. But in brief, Lordship, I am only harping on this at this stage. I'm not claiming anything further. And why I've been reiterating, Your Lordship, is that the other cases are different, Your Lordship, because in the other cases, all the three upgradations have been given. It is not their case, they have not got.
So what is their case?
Their case is regarding pay band, which is a totally different issue.
I'm never denying that. Always right from the beginning, I'm saying, my lord, this to be taken up separately.
So this case is only limited to this issue that I have got my first upgradation.
Okay, so it's just a dispute between, you see, what is to be considered an upgradation or a replacement scale.
Exactly, Lordship. Grateful, Lordship. So if this point is decided, Lordship, then whether I am entitled to two further upgradations or one more upgradation, that only remains. Regarding the third upgradation, Lordship, as per MSc, which I am entitled after 30 years, which is in 2019, I made a prayer, Lordship. And that is what I had brought on record by my subsequent affidavit, Lordship. There they do not deny that I am entitled to it. They only say that the matter is sub judice, so you're not getting it now. So my third one, it's not actually disputed in my humble submission. What is disputed is, Lordship, this second upgradation, which they said is second, my humble submission is that is my first upgradation and I am entitled to the other.
So let me try to understand this.
Lordship.
If a personnel has been, given OTUM,
Lordship.
He has been given OTUM, suppose, after the 8th year, and subsequently the ACP schemes come, and after 12 years, so in the 12th year, he gets
Lordship.
the ACP.
Lordship.
So would that be the first ACP or the second ACP?
Lordship, then autumn would be considered as an upgradation.
Okay.
But in my case, admittedly, they are saying I'm not getting autumn.
I'm not talking about you. I'm talking about the
Yes,
the
Lordship,
system
if
as well.
autumn was given, in this case, there's of course another area which I think if we want to open up, then I will respond, that it was initially given and taken away. That is different, Lordship. So it is neither one's case that I have got autumn. That I don't think they will dispute that I have got autumn.
You know, what I'm trying to figure out is this: as regard autumn, ACP, and MSCP,
Lordship.
how would it fit in the scheme of things, as far as the service of the personnel is concerned?
Lordship.
If he has been given autumn, and then subsequently he crossed the threshold of 12 years, he would be entitled to ACP.
Lordship. 12 years and
thereafter ACP scheme has been upgraded and modified, and MSCP comes,
Lordship.
where the period is reduced to
10,
10
20,
years.
30 years.
So how would he?
Then your Lordship, the calculation.
Autumn would be the first upgradation, ACP would be second, and MSCP would be third.
Lordship, slightly different, if I may humbly submit. But in this case, Lordship, we can leave out autumn because autumn is not in question at all in this case.
No, I'm not talking about this. Generally.
Lordship, it would differ from case to case. Because, Lordship, it depends on when these two schemes have come into effect, Lordship, and how was the incumbent placed at that point of time. That would be relevant, Your Lordship. In my case, Your Lordship, my case is, I would say, simpler than the others. Autumn is, I was just explaining that what are available. In this case, autumn is not in question. I have not got it. They say that I am not entitled. Very good. They have not given it to me after 8 years.
But in the meantime, you have already got the upgradation of 5,500 and
Lordship, it's
Right.
not an upgradation, my humble
it's not
submission.
not upgradation, but you have got that.
It's a pay scale, Lordship.
A pay scale?
Pay scale all over India, everybody would be getting. So I have got it. Wrongly it was shown. I pointed out, they corrected it. So it's a replacement pay scale. It is not an upgradation, and that is the bone of contention, Lordship. So the first upgradation is given to me only in 2013
Right, understood.
with effect from 2008. And this fact, Lordship, is brought home by this document which I was reading just now, because they themselves admit, Lordship, that 5,500 and 9,000 is the core pay scale of a proofreader. The second upgradation is 6,500, 10,000. They themselves are saying, supposing first step is 5,500, 9,000, second is 6,500, 10,500. So, Lordship, they have given me 6,500, 10,000. So that should be my first, as per their showing. But they say this is not your first, this is your second. They are saying your first 5,500, 9,000 is your first upgradation. Which, my humble submission, Lordship, is not an upgradation, admittedly, on several counts, because it is admittedly a replacement pay. It's a pay scale which everybody has got throughout the country. It has got nothing to do with promotion or upgradation.
Which was acknowledged by Nehu.
Which is, even when they are giving to me, Lordship, because they have not given on their own. When the wrongly proofreader was shown as 4,000, 6,000, I represented, Lordship, that this is wrongly shown. This is the post of proofreader as per DOPT is 5,500, 9,000. Here it has been wrongly shown as 4,000, 6,000. Kindly correct the anomaly and give me my what is due to me. On my application, Lordship, it was corrected and given. And it is, again, it's just a correction, Lordship, of the pay scale, which is due to me. So now they cannot turn around and say that is your first upgradation. That's my case, Your Lordship. So my prayer, Your Lordship, in a nutshell, if Your Lordship is pleased to glance at my prayer for a minute. Lordship, I'm coming to the relevant portion, which your Lordship will find at page 26.
Yes.
In brief, Your Lordship, this is of course with the equivalent grade pay, so it might look confusing, Lordship. But briefly, that in 99, Lordship, because I joined in 89, 99, 10 years, so I'm entitled to my first upgradation. 2009, I should have been given my second upgradation.
99 or should it be 2001?
99, Lordship, as per, because after that MSCP has come into effect. By 2006, MSCP has come, Lordship. So now MSCP is effective, Your Lordship. So after MSCP has come, Your Lordship, I am entitled to 10 years, 20 years and 30 years. As per that, Lordship, 89 I join, 99 should be my first upgradation. So if it has not been given, Lordship, what my prayer is, it should be from that date. Naturally so, Your Lordship. With retrospective effect from whenever it was due to me, naturally, Lordship. That's my case. The second upgradation, 2009, and the third upgradation, 2019. Now, in the meantime, what has happened, Lordship? that aspect I'm not opening up because it looks very confusing even to me, Your Lordship. Because the 6th Pay Commission has come into effect. Now, when the 6th Pay Commission has come, Your Lordship, what it has done is number of pay scales have been merged together. And they have been put in a particular pay band. So that aspect, Lordship, if I open up, it will take a little time.
If I recall correctly, merged and taken out again?
No, nothing. We need not go into that. My case is because this is again general, all India. It's nothing. It's nothing specific to me, Your Lordship. All these scales have been merged. So if I was getting that particular scale, now it has become this as per the merger. So I'm entitled. It's like a chart, Lordship. If I was getting X, now after the 6th Pay Commission, these scales have been merged. Now you're entitled to Y. So I'm claiming that only. I'm only saying that my first upgradation should be from 99. Second upgradation 2009, and third is 19. And what they are claiming as the second upgradation is my first upgradation. As such, I am entitled to 2 more upgradations.
Yes.
Lordship.
Yes.
If we open up the Pandora's box, Lordship, of course, we'll go on and on because there are affidavits
I'll
from both sides, which
I'll
I'm
try
not trying to open
I'll
up at
try
this
to
stage.
keep it very short. A few things admitted by learned friend. She's not going into the merger. So, my lord, I am not bringing merger here. Her only simple contention is this thing. In her whole service career, she has been given only 1 upgradation. So, she is entitled to 2 more as per the scheme. That is the thing, my lord. So, my lord, my endeavor, what she is saying, my lord, the crux of the issue is the pay scale granted to her ultimately, your lordships, that is 5,500 to 9,000. Ultimately, not initially. Initially given 4,600, 4,000 to 6,000. That we say the replacement pay scale. Then thereafter, my lord, it is not placed. I will place before your lordships. We considered him under OTUM and granted him the next higher grade. That is 4,000 to 7,500. I have annexed. Then ultimately we have given them 5,500 to 9,000. And we have categorically mentioned their higher pay scale. And that happened way back in 2001 or 3, my lord. That was never challenged. But anyway, my lord. So this is the crux of the issue, my lord. Once this is clear, my lord, if your lordship thinks, no, this is a replacement pay scale, obviously she is entitled to a 2 other scale. But if it is not a replacement pay scale, my lord, then very correctly in 2008 she was given the 2nd pay scale. Then 3rd, I don't know, my lord, whether it has been given. If not given, he will be entitled. So my entire endeavor, your lordships, to convince your lordship, my lord, and on the basis of the records, that whatever the pay scale ultimately that 5,500 to 9,000 was given to the petitioner was not the replacement pay scale, but that was given by way of upgradations, by way of higher pay scale, and that was categorically mentioned in the impending communications. Now, how, my lordship, need to understand that. Now, my learned friend was repeatedly referring to all India. This is an all India phenomenon, so it should have been happening. This post is, my lord, whatever pay scale has been given to the reader, all India basis. That your lordship need to understand. Now, my lord, I'll go back again. What is the university? University is a statutory body, my lord, under the, before it was, my lord, MHRD, now I think Education Department, set up by an act of the Parliament. So as such, my lord, the employees of the university are not central government employees. Well, they are in a statutory body under the control of the Ministry of Education, Union of India, but they are not at par with the central governments. Now, how their pay revision has been affected, lordship need to know that. Now, after every 10 years, now here we are concerned with the 5th Pay Commission, which became effective from 1996. Now, what happens, my lord, after my lord, pay revision was carried out for the central government employees, my lord, the recommendations are accepted by the Government of India. Then this has been made into a rules in exercise of the power under Article 309. Like in the instant case, my lordship is holding the book. A rule has been framed. This is concerning 5th Pay Commissions rules, my lord, 1997. Now, following this, what happened, my lord? An independent exercise is taken up by the UGC along with MHRD as it was then, and they, my lord, prescribe what should be the pay scale in consultation with the Ministry of Finance. What should be the pay scale of the non-teaching staff of the employees of the university? Because apparently, if your lordship go into
all central universities,
if your lordship go into these central rules, there is no provision for teachers. We have teachers also. Now, who will prescribe, my lord, the revised pay scale for teachers? Not by this central government, your lordship, because that is an independent exercise. Lordship will go through it, know where the professor, assistant professors are mentioned. They are not included into it.
is regarding
No, my lord.
non-teaching staff.
Well, let me finish here. If she wants to rebut something which is not correct, she will say. Now, my lord, what happened? So far, the fifth pay commission is concerned, my lord. After the exercise was over, rules were framed. Now, Ministry of Finance, Government of India, issued a notification, my lord. Issued a notification, your lordships. That is, my lord, at Annexure A of my additional affidavit dated 8/3/2019. Additional affidavit. Page 40. Well, I'll just read, that's very important.
8/3/2019.
8/3/2019. At page 14, my lord.
Annexure 1A.
Annexure A.
Yes.
My lord. That is dated, my lord, 2nd December 1997. Now, your lordship will keep it in mind, my lord. The fifth pay revision came into effect from, my lord, 1/1/96. Now, this following this, my lord, now, lordship, this is named as Office Memorandum. Now, pay revision of employees of quasi-government organization, autonomous organization, statutory bodies, etc., set up, founded, controlled by the central government and regarding. So these mean for, my lord, the statutory bodies, autonomous organized under the control of the Union of India. Now, admittedly, my lord, the university is a statutory body, my lord, under the Union of India. Now, paragraph 1, very important, your lordship. All Ministry of Home Affairs, etc. are aware the government have already issued orders regarding revision pay scale of central government employees on the basis of the recommendation of the 5th Central Pay Commission as accepted by the government. It has been decided that these orders may be extended to the employees of autonomous organization, etc., whose pattern of emolument structure, pay scale and allowances, in particular DNL allowances, the house rent allowance, city allowances, are identical to those central government employees. This is further subject to the stipulation that condition of service of the employees of these organizations, especially those relating to the work hours, payment of OTA, etc., would also be exactly similar to those government department. There is no objection, my lord. This lordship will take note. There is no objection to the autonomous organization, etc., adopting the Central Civil Service Revised Pay Rules 1997. It may, however, be clarified that the revised scale of pay as incorporated in Part A of the first schedule, that is the most important, my lord, I am relying on this, only Part A, this is, Part A of the first schedule to the rules, if it alone be adopted. The language is very clear and categorical. They have not given any option to the university. They said confined to the scales we have mentioned in Schedule 1, Part A. Not beyond that. It may further be added that the revised scales would be admissible to those employees who opt for these in accordance with the extant rule. Likewise, deduction on account of the provident fund, etc., etc., my lord. Now, your lordship, will come back to these rules. CCS Revised Pay Rules 1997. Now, it has a schedule, which is called, my lord, first schedule. Now, first schedule has 3 parts. Part A, sorry, my lord, 4 parts. Part A, Part B, Part C, Part D. Now, my lord, as part the instruction, as part the, my lord, communication, we are authorized only to adopt Part A. Now, my lord, Part A is mean for, my lord, what it say, your lordship. If your lordship is holding, my lord, which book, I don't know, is my book may not tell you, the page may not tell you, your lordship. If your lordship kindly take the pen and come to the first schedule, Part A.
First schedule, Part A.
Part A. Now, my lord, what is the revised scale for posts carrying present scale in group A, B, C, D, except the posts which are differently, revised scales are notified separately. Now, lordship will see one unique thing about this Part A is, now these, only the present pay scale and their corresponding revised pay scale has been mentioned. Posts are not mentioned here, your lordship.
Yes.
Posts are not mentioned. Only the existing and the revised pay scale has been mentioned. Now, Your Lordship, kindly come at serial number 7.
Yes.
Now, serial number 7, Your Lordship, they have mentioned as many as 3 existing pay scales. 1200 to 1801. Then next is 1200 to 2040. Then, my lord, 1320 to 2040.
Yes.
Now, my lord, my learned friend has already pointed out, I was initially appointed, writ petitioner was initially appointed, my lord, in the pay scale of 1200 to 2040.
Yes.
But subsequently, when he was given a regular employment, my lord, he was given a slightly better pay scale, my lord. Though that was not the approved pay scale, but my lord, university, we always maintain a, my lord, pro-employee, my lord, approach. So we have given him a slightly better scale, that is 1320 to 2040. But that will not have much consequences for the reason, all these pay scale, 3 pay scales, my lord, merged into an identical pay scale. And what is this identical pay scale? 4,000 to 6,000. 4,000 to 6,000. Now, my lord, this is the instruction, this is the communication, this is what came from the UGC. Now, what we are required? Now, we are required, my lord, to adopt this pay scale under Part A only. Not, we cannot go to Part C, Part D, my lord, we are not authorized. And then we are required to incorporate this in our ordinance. Now, university has, my lord, certain rule-making power. University has been originally set up under an act with certain statutes. Now, the acts and the statutes further say, university can make further rules, my lord, which are called ordinance in certain manners. For example, my lord, revised pay scale, etc., etc., etc. Now, my lord, after this communication came, my lord, after this has been affected, what happened, your lordship? What happened, your lordships? This has been incorporated in the ordinance. My lord, I don't know, your lordships. Time for recess, so we'll come back. It's 1:16 already.
So we'll continue.
Yes, my lord. We'll continue. But I won't take much time, my lord. Maybe another half an hour I'll finish it.
As your lordship pleases.
My lord, because we have gone through, my lord, I won't make it long. See, another half an hour I'll conclude.
Okay, if we can wrap it up by 1:30, then we'll continue.
Lordship.
1:30, maybe half an hour. Half an hour.
Fine.
Lordship, will continue now or will come back?
We can continue.
Lordship.
It's up to you.
No.
If
It's
you
up
say,
to no, my lord.
I can.
No, since this is my lord brag.
I can be here till.
Lordship has been right from the morning.
Till 1:30 or maybe 10 minutes after that, if you say so. After this, do we have any other matter?
Others are also waiting.
Connected matter.
Yours, I don't think we'll be able to do it today. So you can take a break for the day. Let me just see.
Shall I continue, my lord?
Please, just a moment.
Yes. So, my lord,
Just a moment.
Lord.
In 27 done. Who is here? 27? Sangriso. Yeah. So we'll take it up.
Lordship, we have received copies of the additional affidavit. I think the Lordship may fix this matter for hearing on the next day.
The 28 also will be seen.
So 27, list this matter after 1 week.
Lordship, similar prayer for 20.
1 week.
28 also seen.
28. So list this matter after 1 week. Into
Item number 32. 32.
Who's there in 32? You are there in 32? Yes. You are ready with the matter?
Yeah, we are ready. From the other side.
Who's there? Yes, right. In that case, if we have any other matter, after this, we'll break for lunch and come back.
No, Lordship will come back.
What I was, because I think my learned friend is also not, going
No,
at
madam,
length.
let me complete my submission, madam. I'll complete. I won't
No,
take
so
much time.
what I was, if your lordship pleases, lordship, till 1:30, if we are continuing, your lordship, then if
Well,
he's
lordship
able
will
to,
come back at 2. I'll come back at 2. I'm here. I don't know.
not that, so that it till 1:30 we know what is his case, then lordship, if required, it can be fixed
We'll
in the
start
second half, or else.
What we can do is, yeah.
I started through, madam. I have already closed down. My lordship is coming back at 2.
So he'll not take time.
Yes.
Lordship, then looks like we are going till 4.
No, I'm not going. I'm not going.
Which I wanted
No,
to
no,
avoid.
this
That's
I'll-
why I didn't
no, no,
open
I'll-
up my
I'll-
file at all, Lordship. I
No, I'll
restricted
conclude.
myself
I'll
to.
conclude. I'll conclude in short time.
In any case, I believe, see, of course, now since you have made your submission, otherwise it should have been just to refresh the court.
Well, sort of refreshing, madam. I wouldn't go too long, madam. I wouldn't go too long. Lordship.
Lordship.
Good afternoon. My Lord, I crave my Lord's indulgence. My Lord, item 32 of the hearing list. My Lord, I have some difficulty today, my Lord. If this matter is taken up any other date.
20?
32. 32, my Lord. Yeah. I've already sought their consent also.
The 32 on pre-made by the state respondent, not objected to by petitioner. This is matter of the 3 weeks.
Obliged, my Lord.
Second call from daily cost list, item number 22.
I'll make my endeavor to give it brief and short, Your Worships. Now, my Lord, the crux of the issue, my Lord, as my learned friend has pointed out, my Lord, entire thing hinges on the scale ultimately, I'll say ultimately given to the writ petitioner, that is 5,500 to 9,000, ultimately given, initially not given. Now, was it a replacement pay scale or was it a higher pay scale, my Lord? That is, if it is a, my Lord, replacement pay scale, obviously, then under the schemes, first, second, third, they are entitled to all. Now, my Lord, I'll show Your Lordships, this was not a replacement pay scale, but a higher pay scale. So, my Lord, as I have pointed out, Your Lordship, after the 5th Pay Commission recommendations were made and accepted by the government, these were formulated into a rule that is called CCS Pay Revision Rules 1997. One book Lordship is holding. Now, my Lord, these are generally applicable to 3/4 kind of people, generally the staff of the central government. Then, my Lord, the certain staff of the central government, part B. Part C, my Lord, certain officials of the department. I'll take my Lord to this, and so on and so forth. So for the university, as I pointed out to Your Lordship, university employees of the university are not central government employees. University is a statutory body created by an act called Northeastern Hill Universities Act 1972, made by the Parliament of India. And admittedly, my Lord, this is a central university under the effective control of MHRD, Ministry of Education. Now, so far the pay revision of the staff of the central universities are concerned, my Lord, this is an independent exercise, my Lord. Of course, it coincides, my Lord, with the pay revision of the central government employees. This is an exercise taken up by the UGC. Now, my Lord, UGC is the financing, sponsoring and controlling authority. So far the matter of finance is concerned, Your Lordship, we cannot take a decision of our own.
So UGC have its own pay commission revision committee?
I'll just come to that. UGC normally, my Lord, UGC is a, my Lord, regulatory body. This is also created by an act of parliament. So far the finance and other matters are concerned, my Lord, involving financial implication, it has complete say in the central government, central universities, my Lord. Now, my Lord, normally what happened after the pay revision of the central government is affected, then the UGC examine those pay revision affected by the central government, then taking into consideration the situation prevailing in the university, my Lord, using their expertise, they extend it formally. Now, which part, what part, my Lord, it is up to the UGC. And Lordship will keep it in mind, we are bound by the direction given by the UGC because they are the regulatory authority. Entire finance is routed through them. It's from the Ministry of Finance, MHRD, then UGC. And in the act, it categorically say, if any university violates, my Lord, they may financial and other, my Lord, help may be stopped immediately. So we cannot. We are under the effective control. Now, coming back to this case, in 97, my Lord, this rules was framed after the pay revision of central governments were accepted. And thereafter, Ministry of Finance issued a notification in the month of December, which I have taken, my Lord, already in the additional affidavit. Page 14, my Lord, Annexure A. This is following the 5th pay commission. My additional affidavit, Your Lordship, dated March 19. Lordship will come kindly to page 14.
Yeah, this is the one you have
I've just
read just now.
now. My lord, again, I will not read the entire. The opening paragraph, very categorical. Language is very categorical and clear. It says the autonomous bodies, statutory bodies under the control of the central government, they can follow this pay revision affected by this CCS pension pay revision rules 1997, but they will have to confine to Part A of the first schedule.
Yes.
Part A of the first schedule. Lordship will keep it in mind. We cannot go beyond Part A. We cannot go and pick up a pay scale from Part B, C, D. Then we are violating this finance. We are violating the UGC regulations. This is not within our competence. We just cannot give a pay scale prescribed in some other part. We confine ourselves within this pay scale. Now, my lord, the same affidavit, your lordships. Now, following these, your lordships, after formal communication from the UGC, also a communication came. Following these communications, now university, what the university did? University incorporated these pay scales. Now, Part A. What is Part A, my lord? I have already referred to. Part A, my lord, if your lordship look into Part A of the first schedule, these will be there in the books. The page may not tell you with mine. Part A, lordship has got it.
Yes.
Now, my lord, these, my lord, the existing pay scale and the corresponding revised pay scale has been provided in column 2 and 3, 3 and 4. Now, my lord, we'll come to serial number 7. Now, serial number 7, 3 existing pay scale have been mentioned here. That is 1,200 to 1,800, then 1,200 to 2,040. Then another pay scale, my lord, 1,320 to 2,040. Now, all these 3 has been merged into a single identical pay scale, your lordship. My lord, what is that? 4,000 to 6,000. Now, admittedly, my lord, the writ petitioner was initially appointed, my lord, in the pay scale of 1,200 to 2,040, pre-revised. Subsequently, when he was regularized, he was given slightly better pay scale, that is 1,320 to 2,040. But that will not make much difference because all these were merged into a single pay scale, that is 4,000 to 6,000. So these being extended to the university, being part of Part A of the first schedule, what the university did, my lord, come to page 24 of the same additional affidavit. Now, my lord, as I said, my lord, university has a set of acts. We function as per the acts. Our function has been defined of different authorities. Then we have statutes. Then we have ordinances. Now, ordinances are like, my lord, rule-making power of the university. Now, in pursuant to that power, lordship will come to page 24.
Yes.
The appointment and emoluments of employees under clause such and such, section 26, the manner of appointment, etc., the corresponding, paragraph 2. The pay structure, emoluments, allowances, and other fringe benefits in respect of the non-teaching employees, other than those from whom provision has been made in the statute, shall be similar at par with those corresponding levels which exist in Government of India. Pursuant to the recommendation of the 5th Central Pay Commission and approved by the UGC for the employees of the university, that which has been approved. I have pointed out, my lord, finance, Part A. So exactly, my lord, we have laid down what are the revised pay scale. Now, lordship will kindly come to, my lord, next page, serial number 7. Serial number 7.
Yes.
Column 1. Column 1, same thing, my lord. 1208, 1800, 120, 2040, 1320, 2040. He was in. These were marked into 4,000 to 6,000. Now, in the last column, we have mentioned these replacement pay scale for whom? UDC, stenographer, etc., etc. Last come, proofreader. We have notified by making a law, rules, ordinance. Ordinance is a rule, my lord, rule-making power of the university. And once the rule is made, these become a part of the act. And once it become a part of the act, unless it challenged, it will hold the field. That is the law, my lord. Unless it is challenged before the appropriate court and it is struck down, this will hold the field. This was never challenged. Now, when is the date? This was way back, my lord, if I am correct. This was notified, my lord, way back in 98. Lordship will kindly come to page 21, my lord, because that was done in a meeting minutes of the meeting held on 8th May 1998, 21. So Lordship will see here, my lord, the replacement pay scale of the proofreader, that is the read petitioner, was notified by making an ordinance following the direction of the UGC, following the circular issued by the Ministry of Finance, and made into a law, notified, 98. He never challenged. When he filed this writ petition, 2015, now what he is saying, he is saying no, 4,600 was not the replacement. I represented, ultimately it was corrected, and what was granted to me, 5,500 to 9,000, that was the replacement scale. That is absolutely wrong. Now, my lord, give me that synopsis. Give me the amended writ petition. Now, my lord, pursuant to this ordinance, if your lordship kindly come to their amended writ petition, page 31, annexure 4.
Yes.
Lordship has got. Again, a formal notification was issued. That was in the rule book. Then a formal notification was issued. Then your lordship will, my lord, kindly come to serial number 7, same thing. What is the replacement pay scale? We have categorically mentioned against the serial number, proofreader last. 4,000 to 6,000.
Yes.
98. Now the next page, if your lordship comes, annexure 5, that is a representation dated 4th July 2000. Well, this is important, your lordships. Now what he says, what is his grievance? Lordship will come, my lord, from the bottom, if your lordship come to the second paragraph from the bottom.
Yes.
My lord. Thus, it is learned that following the Executive Council decision, the university is going to extend the upward movement scheme to the eligible employees who have completed 8 years continuous service. I have completed 8 years of service on such and such. In this connection, it is learned that the proofreader is being considered to be placed in the pay scale of 4,500 to 7,000, while the UGC stenographers has been placed in such and such. Now that's the first schedule of the report of the UDC stenographer are in the same as in mine, are allowed to be placed in a scale of 5,000 to 9,000, allowing quantum jump. And now he is saying that quantum jump to approved pay scale to such and such. I, as a proofreader, may also be granted the same upward. Lordship will see in his representation what he says. Place me in that pay scale, 5,500 to 9,000, as has been given to the UDCs. Because UDCs were also in the pre-revised same pay scale. And then what language he used, phrase, your lordship will see, as upward scale. That means upward scales means a higher pay scale. He himself made a request. Please, he never said, my lord, this is a replacement pay scale. Place me in this higher pay scale.
Yes.
Now, my lord, there were certain facts which were not narrated, your lordship, which I have stated in my affidavit. In fact, lordship query was, my lord, how this works. This SCP, MSCP, that's very important, my lord. The relevant part I will take, your lordship. Now, SCP, my lord, came into effect, notified in 99. And this was holding the field till 31st August 2008, holding the field. From 1st September 2008, this was replaced by a new scheme called MSCP, Modified Whatever Career Scheme. So till August, this was holding the field. Now, this person, he also made representations, my lord, because before, my lord, this SCP was notified in 99, there was a scheme called OTUF, Autumn, Time Upward Movement. And what is required for upgradation there? 8 years of service. So he made representations and that I am eligible for it. Grant me this. And we granted him this. These facts were suppressed in the writ petition. In my additional affidavit, I will take my law to that. Lordship will kindly come to Annexure F, my additional affidavit, page 36. June 2000 order. Lordship has got it.
Yes.
Well, I'll just read it. This is dated 12 June 2000. On the recommendation of the Departmental Promotion Committee.
Just a moment.
Lordship. Page 36, ma'am. Of my additional affidavit.
Additional affidavit dated?
Affidavit dated, my lord, March 2019. Additional affidavit.
Just one.
Just before this. Lordship has got it. Yes, I read it. My lord, this is dated 12 June 2000. On the recommendation of the Departmental Promotion Committee, the Vice Chancellor, Northeastern Hill University, Shillong, is pleased to grant one upward scale of pay under the scheme of one upward movement in the scale of pay to the non-teaching employees detailed in annexure such and such. The other terms and conditions, etc., etc. Now, my lord, it is been laid down in the next page in the chart.
Yes.
The relevant part I have annexed. Lordship will come to at page 37, serial number 150. Sri S. Datta, proofreader. Now, his date of joining, my lord, 27/1/89. Now, he completes 8 years of service on 27/1/97.
Yes.
Now, next column, your lordship, his pre-revised pay scale was 1320.
Yes.
His replacement pay scale after the 5th pay revision was effected with effect from 1/1/96, 4,000 to 6,000. My lord.
Yes.
Now, my lord, ultimately the last column, your lordship will come. Lordship will come. He has been placed, pre-revised, he has been placed under the OUTM, he has been placed pre-revised under 1,400 to 2,300. And your lordship, if you come, my lord, revise 4,500 to 7,000. Now, 4,500 to 7,000 is the next higher pay scale from 4,000 to 6,000. Lordship has got it.
Yes, I've got it.
Lordship has got it. So he has been placed. Now, Lordship will again look into the chart that part
But
A.
it refers to the same date.
Lordship.
It refers to the same date, 1196.
Lordship. 11, yes, 1196. No, this is not from 1196, your Lordship. Revised, they have mentioned revised with effect from 1196. But he has been given this benefit, if your Lordship will come to third column. Effective date for placement to the upward pay scale, 27/1/97.
With effect from?
Yes, with effect from. Now, in the last column, they have mentioned that this has been revised. This has been revised. Now, what is the revised? Pre-revised is if your Lordship come to second column from the last, then it is 1,400 to 2,300, and the revised is 4,500 to 7,000. Now, my lord, this 4,500 to 7,000, if your Lordship look into that chart, my lord, that book, part A, this is serial number 7 was the replacement pay scale of the proofreader. And where's the book? Lordship will come to serial number 8.
Yes.
Serial number 8 is the next higher pay scale. Now, what is the next higher pay scale, my lord? 4,500 to 7,000. So, under OTM, he is entitled to the next higher pay scale on completion of 8 years of service. So, on completion of 8 years service, we had placed him. It's not that we have never placed him. We placed him into that pay scale. But he still had a grievance. What he was saying, then came, my lord, that representation I went through. That representation, what he is saying that I got the information you have placed me in 4,500 to 7,000. I am not happy with this. please pay me in the pay scale of 5,500 to 9,000 as a higher pay scale. He has used that word. He has used some other language, my lord, as a upward movement. He is admitting this is an upward movement. All this happened in 2000. Now, my lord, ultimately what the university did? Give me that synopsis. What the university did, my lord? We in the situation, my lord, since he was still representing that he is losing out because this is not the appropriate. He never said that this is the replacement, basically, higher pay scale. There are other similarly situated people who were getting the same pre-revised pay scale. They have been placed in 5,500 to 9,000 as a higher scale. He is admitting. So, place me in the higher. So, university constituted an anomaly committee to look into the grievance, not only he, others also. Now, my lord, what happened there? On 3/7/2000, university notified a committee to look into the anomalies, not only of the petitioner, others also. Now, my lord, if you want to see it, your lordship, this is a long one, my lord, I will not trouble your lordship with this. This is, my lord, Annexure G, page 38 of my additional affidavit. Committee was constituted. Now, my lord, the decision of the said committee. Now, committee was asked.
Yes. This is a notification.
My lord.
This is a notification.
Notification. Annex G.
Yes.
Then they submitted a, my lord, report. Now, this is a committee constituted to look into the team, to look into the matter and make recommendations. Recommendation is not a decision. Lordship will keep it in mind. Decision only the appropriate authority take. Committee, what they suggest many things, do this, do that. It is ultimately up to the authority of the university to accept or reject. Now, what happened, your lordships? They have given their findings. Lordship, it's a long one relating to other posts. We are not concerned, why not? We are concerned with the proofreader. If lordship comes to page 47, serial number 11.
Yes.
I just read it. Page 47. The committee examined the case at 11, my lord.
Yes, yes.
Admissibility of appropriate scale of pay to the proofreader of Nehu Press. The committee examined the case in depth and details and felt that only the incumbent in the post who does not have any scope for career advancement and to whom the university granted the pre-revised pay scale 1 through 2040 higher scale should be granted the revised pay scale of 5,500 9,000 with effect from 1 as granted to the Government of India Ministry of Personnel and Public Grievances and Pension, particularly in view of the tag UGC was not prescribed any pay scale for this post. Moreover, the consideration of the policy of the university to grant onward upward movement 8498, the committee recommend the following pay scale may be granted to the proofreader. Now, this is the court pay scale is this. My lord, they are saying in the first column, your lordship court pay scale. Against this, they are mentioned what the writ petitioner was doing pre-revised one, and what is the revised pay scale. There also they have mentioned 4,000 to 6,000.
Yes.
Scale of pay. Then next they have mentioned scale of pay under one upward movement. Now they are saying under one upward movement, under the pre-revised pay scale, it should have been 1640 to 2900. Lordship. And the revised it should be 5,500 to 9,000. Now your lordship will see OTUM one time upward movement. Next scale 4,000 to 6,000. Then if a person is eligible, then he is get a slot in the next stage, not a quantum jump. Now my lord, this is only a recommendation and there is a fallacy in it. What is the fallacy? If your lordship kindly go into that party. Lordship will go to part A, my lord, in that book.
Yes.
No. Proofreader was at serial number 7. Lordship will get it.
Yes.
My lord. Under OTM, if he is eligible, then he is entitled to go to serial number 8, next highest stage. Now, what is the next highest stage? It is 13502220. It has been combined, my lord. Another is 1400222300. And the revise is 4,500 to 7,000. But what the committee recommended, 2 quantum jump. Instead of placing him in 8, they say no, place him in 10. That means virtually they recommended 2 quantum jump to place him there. And that was only a recommendation here. So they said place him in this. Since in other ministry, which is in part C, they are following this, you allow him this also. So this was the thing, your lordship. Now what happened? This was a recommendation. This was placed back again before the committee, executive committee. Now what the executive committee read, your lordship? Lordship will come to kindly come to page 53, my lord, the meeting of the executive committee. Page 54.
Yes.
Item number 4. This report was placed, and what decision the EC took. EC is the only competent authority to take a decision, not a committee. What decision it took, my lord? Item number 4. At page 54, pay annually in respect of non-teaching staff of the university. The council considered the recommendation of the pay anomalies committee appointed by the university and resolved to refer the matter to a committee consisting of the following, and the chairman was authorized to take action on the committee's recommendations. Now, it has 2 parts, Lordship will see. They were not happy with this recommendation. So further they have referred this to a smaller committee now. Now this smaller committee comprised of registrar, finance officer and internal officer. So these report, instead of taking into a decision, obviously for all those anomalies, this was referred to a smaller core committee. And further, your lordship will see, they have authorized the chairman. Now who is the chairman? Vice Chancellor. He is the chairman of the executive. He said whatever recommendation this core committee takes now, on the basis of this recommendation, take a final decision by the Vice Chancellor. That was the decision. They have never accepted this. Now, in pursuant to this, what happened, your lordship? Lordship will go to kindly come to page 60. That is part of Annexure J, starting from 56.
Yes. Page 60.
60, man.
This is key.
Right, lordship. Now, my lord, before that, just to avoid any confusion, if I can tell my lord, these annexures start from page 56, Annexure J.
Yes.
If I can take your lordship on 57 to clarify that this is a decision taken by that core committee. Well, that is mentioned at page 57.
Yes.
Again, you see, your lordship, page 2nd paragraph. The Executive Council considered all the items and resolved to refer all the items to a committee consisting of Register, Finance Officer.
Just a moment.
Lordship at page 57. Lordship, my lord, from the top, it is the first, second, third small subparagraph. 1 line subparagraph. Lordship has got it?
Yes, yes.
Consider all the items and resolve to refer all the items to a committee consisting of Register, Finance Officer and Internal Audit Officer. Council also authorized the chairman to take action on the recommendation of the said committee. So again the same thing. They are saying we are referring it to this core committee, and ultimate decision on the basis of this report will be taken by the Vice Chancellor.
Yes.
Now what is the decision, recommendation? I will not say decision. What are the recommendation of this committee? This is as page 60 pertaining to proofreader. Page 60, serial number K.
Yeah.
The pay scale of proofreader. The committee had threadbare discussion on the issue. It was a fact that the pre-revised pay scale of the group of official proofreader was 1320-2040, whereas the pre-revised pay scale of upper division clerk was 120-2040. It is also a fact that UDCs, when we allowed the benefit of one-word upward movement, they were placed in the pay scale of 1640-2900, that is pre-revised, and corresponding revised pay scale of 5,500 to 9,000, whereas the proofreader under the said benefit was placed in the pay scale of rupees 4,500 to 7,000. That is under OTM, such and such. The committee noticed that the University Grant Commission has not prescribed any revised scale of pay for the said post, whereas the Government of India Department of Personnel, Public Grievances and Pension prescribed the scale of such and such as the core pay scale of the post of readers. The committee further felt that under the present setup, there is no promotional avenue for proofreader in the NEHU services. The committee thus decided that the proofreader of NEHU be placed in the scale of pay of rupees such and such with effect from 90 years and be treated as core pay scale, since there is no promotional hierarchy in the grade under NEHU service. The proofreader cannot be granted upward movement. Now, this is the view expressed. They are saying it's a decision, but this is the view. Well, committee cannot take a decision. Ultimately, it is the VC has been authorized. Now, they say two reasons. They say the UDCs who were enjoying the similar pre-revised pay scale as the proofreader, similar pay scale, while they were granted benefit under OTUM, they were placed in the pay scale of 5,500 to 9,000. So why not this benefit also to be given in the first part to the proofreader? Second part, they are saying in the Ministry of Personnel, etc., the Government of India, the proofreader pay scale is 5,500 to 9,000. So they are recommending, they are saying we are taking a decision, they should be given that pay scale as a core pay scale. Here they are saying as a core pay scale. Perhaps they are meaning as replacement pay scale. Now the question is it within our jurisdiction, my lord, to grant a pay scale which is meant for a department under Part C, which university is not supposed to follow? Now what happened, my lord? These are the suggestion, my lord, recommendation of the committee, which was placed ultimately before the VC. Now what is the decision of the VC, your lordship? I have annexed it. Same thing, it is there in their writ petition also. 63, last page, Annex K. 16801.
Yes.
In pursuance of the resolution dated such and such, the VC, the Vice Chancellor of the Northeastern Hill University is pleased to order that the proofreader of the university shall be granted the pay scale of 5,000 with effect from 1/1/96. 5,500 to 9,000. Now the second paragraph. The Vice Chancellor is also pleased to order that the proofreader will not be entitled to benefit under one upward movement scheme in view of granting of the highest scale of pay of rupees 5,000, 9,000. So ultimately, who takes the decision? As authorized by the Executive Council, the VC, on the recommendation made by this various committee. And what is this decision? It will be given with effect from 1/96, 5,500 to 96, but no other benefit. For the reason we have granted this as a higher pay scale. This has been clearly spelled out in this order. And what is the date of this order? 16/8/2001. Now they are saying they have grievance with, they have problem with this wording. They have never challenged it. They have accepted it. In their representation also they have admitted, give me this pay scale as a higher pay scale. So what I want to convey, my lord, whatever they have filed now, they have just made up as a case to get a relief. They have never challenged it because they are fully conscious this was not a replacement pay scale, this was a higher pay scale. Now, my lord, I will come back to your lordship to ACP. Now, ACP and MACP. ACP was notified in 99. Now, what does ACP say? ACP say that any person holding a post where there is, my lord, there is no avenue for promotion, he will be entitled for 2 financial upgradation during his whole service career. 1, 12 years from the date of entry in the service. Another 12 years from the date of first financial upgradation. That means otherwise 24 years from the date of entry. Now this is again a central scheme, my lord. We just cannot follow it. It has to be extended to us by our sponsoring authority. Our sponsoring authority, as I said, UGC. Now UGC had extended it. Now while UGC had extended it, as well as in the scheme, it has been categorically mentioned that while granting these schemes, the employer should keep in mind one thing. Had the employee been granted this kind of upgradation under any other scheme, number one, or by way of, my lord, either under any other scheme or by way of, my lord, restructuring the cadre, if these were given under any other scheme or by employer of his own choice, then that has to be adjusted. If suppose they have given an example, if suppose he has been given during his career under any other scheme or employer of his own a higher pay scheme, then that first is not available. Then only he will get the second. Now, my lord, this is necessary. I'll just take your lordship to the relevant part of those UGC and SAP's scheme. This is amended reparation. Now, lordship, that is, my lord. No, this UGC is liable. This is MSAP. Ministry of Personnel. This is SAP. Now, my lord, the SAP scheme has been annexed at Annexure 7, page 36 of the amended read petition. Page 36, Annexure 7 of the amended read petition. Now, the detailed terms and conditions, my lord, start from page 39. Now, lordship will kindly come to condition 5.1. At page 39, my lord.
Yes. 5.1.
5.1. Just I read it, my lord. True financial upgradation under SCP scheme in the entire government surveyor career of an employee shall be counted against regular promotion. Now, my lord, including C2 promotion. Now, my lord, the meaning of C2 promotion, my lord, C2 promotion means, my lord, placing a person, incumbent, on the higher pay scale without changing the designation, without changing the responsibility. This is same as, my lord, financial upgradation. Including C2 promotion, fast track promotion availed through limited departmental companies, avail from the grade in which an employee was appointed as direct recruit. This shall mean that true financial application under SCP scheme shall be available only if no regular promotion during the prescribed period 12-24 hours have been availed by an employee. If an employee has already got one regular promotion, he shall qualify for the second financial upgradation only on completion of 24 years of regular service under SCP scheme. In case of two prior promotion on regular basis have been received by the employee, no benefit under SCP. So they are very categorically saying these are to be adjusted against promotions, including C2 promotion. That means upgradation. If he has been given one upgradation during his service career, whether under any scheme or otherwise, that is to be adjusted.
So that will be considered as
done first upgradation.
So first
upgrade. That not necessarily under right. This might not. I will come. UGC is very clear.
Okay.
Now this can be by the employee himself. Just he can upgrade, finding that somebody is facing hardship, he can just upgrade. That also has to be adjusted. If two were given under a scheme or by the employee himself, all the two has to be adjusted. That means you will not get anything under SCP scheme. Now, my lord, this is more clearly spelled out, my lord, in the UGC letter. Now, this UGC letter which extended this, because this is a central scheme. Suo motu, it has no application. Now, UGC had to extend, they had extended it, and your lordship, my lord, the UGC notification annexure 13. Annexure 13. 13 page 70. My additional affidavit. Affidavit in opposition. My lord, your lordship, come back to my additional, not additional, my affidavit in opposition filed by the university, July 2015. July, my lord, this is dated July 2015. Affidavit in opposition by respondent number 125. Lordship has got it.
This is, here it is August.
My lord, July 2015. An affidavit in opposition filed on behalf of respondent number 1 to 5.
Yes.
Lordship has got it. Maybe I'm wrong. It might be August also. 2015. Lordship, if your Lordship comes to page 70, the UGC's letter dated 8 December 2000.
Page?
Page 70. Annexure A30.
Yes.
Lordship has got it.
This one.
Now, my lord, this is very important. That's how they have. Now, my lord, this is dated 18 December 2000. Addressed to the registered Northeastern University.
Yes.
Subject SCP scheme for central government civil and employees central guidelines. Central universities. My lord, extension UGC maintained by early. Now it's a government of ministry, personnel grievance department, etc. have an assured progression scheme for central government civil and employees wide there such and such. It has been decided in consultation with the department of personnel such and such became training to extend the assured SCP scheme to employees in quasi-judicial government autonomous organization, etc., set up, funded and controlled by the central government subject to the following conditions. Now they have extended it. This belong to their categorically saying mean for central government. In consultation with the department, they have taken a decision to extend it quasi-judicial authority, autonomous bodies. That's how. Now, my lord, what are the conditions? A conscious decision has to be taken by the concerned board of governors, my lord. This is not relevant. Relevant part will be lordship next page, page 2. This is very important, my lord. It has been clearly spelled out to the conditions. It's page 71.
Yes.
Clause 4. Lordship has got it.
Yes.
It is to be ensured that in case of any promotion, personal promotions, time-bound promotions within bracket, one upward movement, second upward movement, in situ promotion. My lord, I have already defined, my lord, what is situ promotion. Any financial upgradation. My lord, if you forget anything, everything also, no, any financial, any kind of financial upgradation, they have included. Any club restructuring scheme, personal pay scale scheme, any restructuring of cadres, implementation of local cadre review committee recommendation, any large-scale mass stepping up, exercises, etc., carried out by the university resulting into financial benefit of higher pay scale, etc., have to be adjusted against SCP. Now, my lord, this is very clear. This is very categorical. Now, my lord, this is very clear, my lord, because this paragraph, they said any financial upgradation. Mass stepping up. Mass stepping up. Now, my lord, ultimately, university took a decision. Their revised pay scale was replacement pay scale 4,000 to 6,000. After the committee's recommendation, took a final decision and decided to place them in 5,500 to 9,000, which is 2 quantum jump, a higher pay scale. And we have mentioned higher pay scale. So that was a financial upgradation. Now these letters say any financial upgradation granted by the university, that has to be adjusted. Now, my lord, the case of the university, my lord, what was ultimately given to him? Initially, his pay scale was 4,000 to 6,000 replacement pay scale. Then, my lord, he was under OTUM, he was considered and he was placed in, my lord, 4,500 to 7,000 next higher pay scale. Then, my lord, he was still having grievance. We constituted a committee, looked into, they made a recommendation. What my learned friend is passing on, decision of the university. That was not the decision of the university. That was a recommendation. They recommended you give the pay scale of that ministry. We are not authorized, my lord. And ultimately, VC took, who was authorized by the executive, took a decision and they said, no, we'll give you this pay scale to all proofreaders. So this is a mass stepping up by way of financial upgradation, but as a higher pay scale, not as a replacement. And that was categorically mentioned. Now these say very categorically, these are to be adjusted. So, my lord, if it is to be adjusted, that means he got a financial upgradation, my lord, when he was placed in 5,500 to 9,000 with effect from 1/1/96. That was the first financial upgradations. Then if that is the first financial upgradation, my lord, the SCP which was holding the field till 31st August 2008, my lord, then he completes another 12 years from the first financial upgradation, that is 96, 1/1/96, my lord, he completes in the year 2008. But his case was considered in 2013, obviously, my lord. And he was given this benefit with effect from 2008 because he became eligible by 2008. In the meantime, UGC issued further letters. That is very important, Your Lordship. They have virtually cautioned us. Don't deviate. Don't deviate from our instructions. That is at my Lord. This is in page. My Lord, Annexure 5, same affidavit, my Lord. Annexure 5, page 43.
Page?
Page, my Lord, if I'm 43.
43 of your
Page 43 of the same affidavit, my Lordship is holding.
August.
Affidavit, yes. Now, this is, my Lord, dated 13 July 2010. Implementation of SCP scheme 9899 for non-teaching employees of the Central University, UGC maintained Deemed University, etc., etc. This is in continuation in this office letter number such and such on the subject mentioned above, informing the Central Universities, UGC maintained deemed to be university and Delhi colleges that the detailed guidelines of SCP schemes are being developed on the basis of the recommendation of the UGC Standing Committee in the past while considering the individual cases from these institutions and enabling the university to implement the MCB scheme in respect of the remaining cases in the similar lines on their own. A copy of the guidelines prepared by the Standing Committee of the SCP scheme and approved by the UGC is enclosed herewith for guidance and strict compliance. My Lord, what they have mentioned, my Lord, because this is, Lordship it may come to Lordship mind, this is issued only on 14 July 2010. This is for the purpose of deciding, because SCP was holding field till 31st August 2008.
Yes.
My Lord, holding field. So there are many pending cases. For deciding the pending case, again they had issued the guidelines and they cautioned the universities, strictly follow this guideline, don't deviate from it. Now if you Lordship go into the next part of the guidelines, very long guidelines, my Lord, I will not go everywhere. Page 44, paragraph 3. Lordship has got it, 44. Next page.
Yes.
Lordship has got it. Paragraph 3. Small paragraph.
Yes.
While forwarding the guidelines of the subject of the University Delhi College, we are specifically requested to ensure that the financial benefits avail on account of promotion, personal promotion, time-bound promotion, one-time upward movement, second upward in situ promotion, financial upgradation, any kind of financial upgradation, recruiting of cadres, implementation of club structuring scheme, partial pay scale scheme, local cadre review committees, any large-scale mass stepping up exercise, etc., are to be adjusted against SCP scheme. And Lordship has seen the tone and tenure of the letter. They have cautioned us, strictly follow those guidelines, don't deviate. Now here, his case was ultimately considered in 2013. All this letter was before the university. Now could we have deviated? Because admittedly, what was the situation, my Lord? With effect from 1/1/96, ultimately we have given him a pay scale. Ultimately, with initially the replacement 4,000 to 6,000, then under OTUM 4,500, 7,000 we have given. Ultimately, after considering the recommendation as a higher pay scale, categorically we have mentioned in our communication, we have given him 5,500 to 9,000. So that was a financial upgradation. So that was counted as the first financial upgradation. Now, by going by the direction of the UGC, instruction of the UGC, his case for the second financial upgradation was considered in 2013, and he was found eligible from the 12 years from the first financial upgradation, 96. If your Lordship counts, it comes from 2008. So we have granted him the second financial upgradations. What is this for? Now, my Lord, we'll come to the FCC file. Same affidavit. There is one more letter, my Lord, 2011 also. That is Annexure 7, page 62. Same affidavit.
Yes.
That is 12 August 2011. This is also below your Lordship, addressed to the university from the UGC. From the UGC.
Yes.
No, my lord, this is from, I'm sorry, my lord, this is from MHRD. We are under the MHRD, my lord. No, MHRD also cautioned us. Now, dear sir, now this is 12th August 2011. As you were aware, the University Grant Commission has extended modified area progression scheme to the non-teaching employees of the central universities with date 9 July 2010 in pursuant to the Government of India's Department Personnel Letter No. It has since come to the notice of the Ministry that conditionalities prescribed by the UGC for implementations of the aforesaid scheme in terms of para 3 of its aforesaid letter dated such and such are not being adhered to scrupulously by some of the central university, which needs to be looked into at the highest level in the university. It may be reiterated the benefit of MSCP is effective from 1/9/2008 and SCP scheme 9/8/99 will remain applicable during the period from 9/8/99 to 31/8/2008. For the university are required to follow strictly the guideline issued by the UGC wide letter dated such and such. I shall be grateful if you could kindly let us know that the university is taking necessary action in this regard. Accordingly, kindly acknowledge receipt. So again, they have cautioned, like in the pending cases, others strictly follow the guideline and keep us informed about it. So, my lord, in this situation, could we have deviated? Where is the power for us to deviate? Could we have said, no, whatever has been given, this is a replacement basically? No, we could not have. Now, your lordship. So, my lord, that's how the second financial come. Because of this, my lord, I will not repeat. Then came the MSCP schemes. Now, after the MSCP so far, MSCP now says same thing. I can take your lordship again. MSCP said a government servant in his service career, lordship will give it, in his service, not addition to whatever, in his service career entitled to 3 financial upgradation. 10 years, 20 years, 30 years. Then again the same thing, they said if he has got a benefit under some other thing, then if he has got a benefit under ACP, then had to be adjusted. For example, suppose a government employee get 2 financial benefit already under ACP scheme. Then under MSCP again he is not entitled for 3 fresh. Then he will get, my lord, only the 3rd financial benefit. Annexure, my lord, it's better your lordship in a small paragraph. I will take your lordship. Annexure 9, the amended writ petition. Page 45. Amended writ petition, page 45. And this has been, my lord, lordship has got it. Yes, page 45. Now this is the scheme. And lordship, I will take, my lord,
this
the
19, this is 19, this OM.
19th May 2009. Yes. This is the MSCP scheme. Now your lordship, kindly come to page. Kindly come to page, my lord. This is about the scheme. Come to page, my lord, next annexure, 53, annexure 10. That is the letter from the UGC by which MSCP also has been extended to the university.
Page?
Page 53, annexure 10. That is dated, my letter dated 9 July 2010.
Yes.
Now, my lord, if I can read it. A small letter.
Yes, please.
I'm just reading. Yeah? Now, registered Northeastern University addressed extension of modified Asian scheme to the non-teaching employees of the central universities. Now, my lord, will kindly come to paragraph 3. In view of the above, the UGC extend the MSCP scheme for non-teaching employees of central university. UGC maintain deemed university. UGC maintain college affiliated central university and pursuant following Allahabad University. And my lord, the relevant part of your lordship come to page 54. But these are the lordship, it comes to, my lord, I'll just read it, my lord, paragraph 3. I'm sorry, I need to read. In view of the above, the UGC extend the MSCP scheme for non-teaching employees, central university, etc., subject to the following conditions. They have put the conditions. My lord.
Yes.
Number one, where the issued progression scheme was applicable in this institution, the institute control must switch over to MSCP. Where earlier scheme, if any adopted, my lord, lordship will kindly come to condition number 6. Condition number 6 at page 54.
Yes.
It is to be ensured that in case any promotion, personal promotion, time-bound promotion, one upward movement, second upward movement, in situ promotion, any upgradations, any club structuring scheme, personal, any scale schemes, any restructuring, etc., my lord, mass stepping up, carried out by the universities in the past, that is before 8498 and thereafter, the financial upgradation awarded under SAP scheme, if any, resulting into financial benefit, shall have to be adjusted against the same thing. They are saying any upgradation, whether under OTUM, whether under SAP. Now this is regarding SAP. If you have given, or whether of your own, that is also any financial upgradation, not necessarily under scheme, that has to be adjusted. So, my lord, my humble submission, the schemes are very clear, and these schemes are central government scheme. Suomoto has no application. This has been extended to the university. Why the UGC? And Lordship will take note, UGC is not even a party here. Now, my lord, UGC has extended. They have cautioned time and again. And in fact, my lord, subsequent cases, it will come up. Subsequent cases, they have said, if you have given something beyond, then you can think of recovering. And to the extent, because this is a financial implication, huge financial implication, so we cannot deviate from their conditions. So 5,500, my lord, very clear and categorical, that was given as a higher pay scheme. If he had a grievance, he could have come and challenged it. He had never challenged. When he got ultimately, in 2013, we have communicated that now you are getting your second financial upgradation. He came to the court and he's saying, no, that is a replacement pay scheme. But not a word how you will justify that the communication clearly says this is given you as a higher pay scheme. So, my lord, now, my lord, making a suggestion, like the committee also make a suggestions, and I give them a pay scale of Ministry of, my lord, personnel. That only the last point I will clarify, my lord, I will conclude. It is, my lord, that is in part C, if I am not wrong, my lord, this is in part C, I think. Yes, this is in part C. Lordship come to part C, I don't know, my lord, which page it will be. Part C is meant for whom, not meant for the central university. Now she has got it.
Where is part C?
Part C is not, it has to be there. I mean, this has got 4 parts.
Part B is there.
Part C has to be there. Has to be. Because my learned friend has referred to that particular pay scale. That is in part C only. May I help you? I can help.
Do you know when you can get?
Part B. Part C. So, yes. Now she has got it.
Yes.
Now this part C is meant for whom? Revised scales of pay for certain posts in the ministries, department, union territories. How we are concerned, the finances made it very categorical. Strictly confine yourself to part A. Now how can you go to part C?
Yes.
Now my lord, relevant, now my lord, under the, my lord, the relevant pay scale my learned friend has mentioned In my book, it is at page 109. In Lordship's, the book your Lordship is holding, it should be at page 103, my lord. Should be 103. Now, this is under the Ministry of Personnel, Public Grievance and Persons and Pensions. Is it so, my lord? Should be 103, 103, 104, something like that.
Just a minute.
This is under Ministry, my lord, serially numbered Roman number 22 in Roman. 22 in Roman.
Yes.
Lordship has got it. Now,
page 115.
Page 105, your Lordship.
115.
My lord, sorry. Now, this is your Lordship, you see, Ministry of Personnel, Public Grievances and Pensions. This is under Ministry. There exists a post, proofreader, that too in Lal Bahadur Shastri National Academy of Administration. Now, there the pay scale has been revised to 5,500 to 9,000.
Yes.
Now, that is mean for the post, particular post existing, they have categorically mentioned. Nowhere they have given an indication Central University. Cannot be, because Central University confined to Part A. Now, we cannot go and equate with this. We do not know what is the volume of votes.
Yes.
My lord, this depends on many things. Now, right. Now, there are other posts also in this. Then somebody will come. There are other posts, Lordship. For example, I am taking, my lord, to page, should be your Lordship, Lordship, my lord, that is under Roman number, my lord, in Roman 15, 16, 15, my lord. Roman 15.
Yes.
Lordship has got it.
Ministry of Science and Technology.
No. Roman 15.
Oh, 15.
15. This is 15. Roman 15. Ministry of Home Affairs.
Yes.
Now, Lordship will come at serial number 10, proofreader. Lordship has got it.
Yes.
Now, my lord, their pre-rebate was much less, 1,200 to 1,000, less than the university. Now, my lord, it has been revised to 4,500 to 7,000. Are these we are supposed to follow? These are for ministries. They had different pre-revised pay scale, different revised pay scale. When the finance is making it very categorical, go by part way, how my learned friend can say that we should follow this? No doubt that core committee, they also make a recommendation. But that cannot be. University cannot take a decision overwriting the guidelines of the UGC, overwriting the instruction issued by the ministry, MHRD. We cannot overdo. Ultimately, we took a decision and we have made it very categorically. This has been given to you as a high pay scale. That is a financial. He got 2 quantum jobs. So, my lord, whatever my learned friend is saying, my lord, is not correct. He is not entitled. Now, coming to third. Now, third, I do not know, my lord. One reason, obviously, if it is not given by this time, case is pending. If he is, my lord, completed, fulfill the criteria, obviously he will get. That is not a contentious issue here. Contentious issue that 1196 was a replacement. It's not correct. I have taken, my lord, to all the page paragraphs and all. So this is a case, my lord, call for no interference. This is the only issue raised, my lord, I have answered. And one thing last, my lord, because they have relied on some decisions. I am not relying on that. Their own decision is going against them. And just one paragraph. Because here the court says this MSCP scheme, somehow it traveled to Supreme Court. Now Supreme Court says court should not review this, my lord, whatever conditionalities are there. Because these will have a huge financial implications. And these will have a telling effect on the public exchequer. So here Lordship will keep huge financial implications. This person already given 2 quantum jump as fast financial upgradation. He is saying no. He was sitting all over. Do he know it is a financial upgradation? And his representation, he is saying this is a highest scale. Pay me in the highest scale. So any further, my lord, direction to give him further financial in spite of what we have given will have a telling effect. That is there in the, my lord, I can refer their decision, my lord, paragraph 38, along with their synopsis.
What is the citation?
Citation 2020 5 SSC 421.
Para
Para 38.
38.
38.
What does it say?
Small letter. The prescription of pay scale and incentives are matter where decision is to be taken by the government based upon the recommendation of the expert bodies like pay commission and several relevant factors, including financial implication. And court cannot substitute its views, as held in Haryana Civil Secretariat Personal Staff Association. The court should approach such matters with restraint and interfere only when the court is satisfied the decision of the government is arbitrary. Even in case where the court taken a view that the order scheme passed by the government is not an equitable one, ordinarily only direction could be given to the state government or the authority for consideration of the matter and make decision. In the present case, batch of the cases where the respondents are claiming financial upgradation in the grade pay of promotional hierarchy, no grounds are made out to show that the MSCP scheme granting financial upgradation in the next grade pay is arbitrary, unjust, warranting intervention. The implementation of MSCP scheme is claimed to have led to certain anomalies, but as pointed out earlier, MSCP scheme itself is not under challenge. So these are not challenged. So any interpretation, in spite of what, he got 2 quantum jump. You will also look into it. From 4,600 we have given him. So that was a huge financial benefit. So that was number 1. Number 8. So my conclusion, this should not, and UGC is not a party. You will see UGC is not a party. I think Union of India is also not a party, because we are under, my lord, strict surveillance of UGC MHRD. So I can prove.
Lordship, I'm grateful to my learned friend for pointing out certain things which also escaped my attention and which hopefully will help me in my case, Your Lordship. Lordship, one point my learned friend has raised, that I have been given upgradation under autumn. He's claiming. He was trying to show. He says that I have got an upgradation under autumn, Lordship, which I can avail only after 8 years. Lordship. Now, Lordship, I will take your Lordship to the affidavit dated 20th March 2019. Just five minutes I will take. 20th March 2019.
Yes.
Lordship, in one breath, Nehu says they have given me financial upgradation under autumn. In the same breath, the Vice Chancellor, in his notification dated 11/8/2001, says the Vice Chancellor is pleased to order that the proofreader will not be entitled to any benefit.
You are reading?
Lordship, it's page 21. This is by which I was given that replacement pay scale.
According to you, sir,
Lordship, they are categorically saying it.
Yes.
Lordship, kindly see the second part. The Vice Chancellor is also pleased to order that the proofreader will not be entitled to any benefit under the upward movement scheme. So I fail to understand.
Well, small thing.
Kindly let me finish.
Autumn, I never said, my lord. It was given, he was not happy. Anomalies committee, then we have given him a higher school. That is cannot be under autumn. I never said he was given autumn, he was not happy. And in his representation, he categorically said, I'm not happy yet, pay me in the higher school. It's never my case.
So either they have given me autumn, which I can only avail after 8 years, or they have not given me autumn. Lordship, this is...
So this notification says that...
2001 with effect from 1196. Now 89, Lordship, I have appointed. 89, 90, 91, 92, 93, 94, 95, 96. 96, 8 years is not complete, Lordship. If they have to give me autumn, they can give me only in 97. So admittedly they have not given, which is further reiterated by this fact where the Vice Chancellor orders that no upward movement will be given to him. Lordship.
So it means that, you see, as and when you are due and eligible for autumn, you will not be given.
I will not be given.
Since you have already been given this 5,500,
9,000. So this is settled, Lordship, no autumn in my case. No upward movement availed by me under autumn.
Yes.
It is not my case, it is their case.
Yes. Yes.
Lordship. Now, Lordship, the other interesting fact which from this affidavit my learned friend was pleased to read out,
Yes.
and I agree with him totally in this, Your Lordship, that any decision taken by a committee is in the form of a recommendation to the EC. It is not an order, Lordship. It is not binding. I agree totally. So this is which I have been pointing out in page 11 and which he read twice, Lordship. Kindly see page 11 in this very document, Lordship. Page 11. Page 11, para 11, Lordship.
Yes.
That admissibility of appropriate scale of pay to proofreader of NEHU.
Yes.
No, I'm extremely sorry. It is there also, Lordship, but the relevant portion, Lordship, will find at page 18. I'm sorry.
18.
18, para K.
This is the minutes of the April 4th
Of the
meeting.
subcommittee's report, Lordship, which I have also read, my learned friend read twice, regarding fixing of the core pay scale.
Yes.
Lordship, I think we all agree this is the crux of the issue. Lordship, the second part, I will take the liberty to just read the last few lines. The committee noticed that the University Grants Commission has not prescribed any revised scale of pay for the said post.
Yes.
Whereas the Government of India Department of Personnel, Public Grievances and Pension prescribed the scale of 5,500, 9,000 as core pay scale for the post of proofreader. The committee further felt that under the present setup, there is no promotional avenue for the proofreader in the NEHU services. The committee thus decided that the proofreader of NEHU be placed in the scale of pay of 5,500, 9,000 with effect from 1/1/96 and be treated as core pay scale. Since there is no promotional hierarchy in the grade under NEHU services, the proofreader cannot be granted upward movement. So, Lordship, this is a recommendation, as he says. It is a recommendation, it is not binding. Only an authority such as the Vice Chancellor, by passing an order or issuing a notification, it can become an order, Lordship. I agree with him totally. This is a recommendation of the committee, which is taken up in the EC resolution. The resolution is that yes, proofreader has no scope of promotion, so 5,500, 9,000 should be given to him. Also, they say here, because UGC has not fixed any pay for this proofreader. That also they say here, Lordship. There is a slight contradiction here. I'll come to that later. Now, this is a recommendation, Lordship. Now, what happened pursuant to the recommendation? Lordship, the date here is very relevant. Lordship, the date of this resolution is 4/4/2001. Lordship,
Yes,
that you also,
4.
Lordship, can see from page 12. It is this date is very, very important, Lordship. 4/4/2001 is the resolution.
Yes.
It is a resolution that 5,500, 9,000 is the core pay scale of the proofreader. But it's a recommendation. It can only become an order by the Vice Chancellor. Was it done? Yes, Lordship. Kindly come to page 21, which is again the same order, Lordship. This recommendation, Lordship, is 4/4/2001. The order is 16/8/2001. So this is pursuant to this resolution?
Yes.
Clearly in pursuance to this resolution of the committee and the EC?
Yes.
Here, in pursuance of the resolution number dated 4/5/2001, the Vice Chancellor of the Northeastern Hill University is pleased to order that the proofreader of NEHU be granted the scale of 5,500, 9,000. So now it becomes an order, which is binding on the university.
Yes.
That's my limited case, Your Lordship. The committee recommended, after considering everything, EC passed an order to that effect, giving me this pay scale of 5,500, 9,000. Again, going back to the recommendation, Lordship, recommendation says 5,500, 9,000 is the core pay scale of the proofreader. Now, Lordship, this is a two-way relationship. A recommendation of the EC becomes an order only when the VC passes or issues an order or notification is issued. Likewise, Your Lordship, the VC also cannot go beyond the recommendation of the committee or the EC, Your Lordship. So, the EC has recommended as a core pay scale, Lordship. Can the VC now say, no, this is not your pay scale, core pay scale, this is your upgradation? He cannot. Am I clear, Your Lordship? The recommendation is that it is the core pay scale of proofreader. VC passes an order to that effect that you are getting pay scale of 5,500, 9,000. But here he writes, this is their upgradation, which is actually contrary to what the recommendation of the EC and the subcommittee is. So my humble submission, Lordship, this is actually fixing my pay scale, which is the core pay scale, and this is also this pay scale which needed to be corrected as it was early showing 4,000, 6,000. Lordship, what I was saying that there is a slight anomaly when EC is taking this decision, subcommittee. Lordship, that line, they say the committee noticed that the UGC has not prescribed any revised scale of pay for the said post. Whereas my learned friend, all this time he has been trying to say that the UGC has fixed it as 4,000, 6,000, which he was showing to Your Lordship, the book, Your Lordship. He is trying to show that it was 4,000, 6,000. We cannot go beyond it. They themselves are saying that UGC has not fixed anything. So poor thing, proofreader has nowhere to go. We will give him this. It is their case, Lordship. I am nowhere in the picture. So it is actually, Your Lordship, that the proofreader, that is not fixed, so they have fixed it as core pay scale. Lordship, core pay scale, I think all of us understand, is the first step from where one can only go further. It cannot be considered as an upgradation, Your Lordship. There's only one last submission, Your Lordship, I will make. My learned friend has pointed out. Lordship, this one other date is relevant, Your Lordship. When MSCP came into operation, Lordship. MSCP came into operation from 19/5/2009. Lordship, this was issued and it was effective from 1/1/2008.
MSCP.
ACP, Lordship.
ACP or MSCP?
MSCP, Lordship, was from 19/5/2009.
Yes.
So ACP is an operation prior to that, Lordship. So, Lordship, in 2009, when the MSCP has come into operation, Lordship, from then on, Lordship, MSCP is in operation, Lordship will kindly note. From 2009 onwards, MSCP in operation. So, in 2013, Your Lordship, 2013 MSCP is in operation. So, I have got the only upgradation which I have got. They call it second, I call it first. I got it in 2013, Lordship. So if I have got it in 2013, Lordship, it is under MSCP. I'll reiterate myself, Lordship.
Yes, yes.
MSCP, this scheme comes into operation from 2009 onwards. So everything that happens after 2009 is governed by MSCP, Lordship, and prior to 2009 is ACP. So So we are concerned with after 2009. After 2009, 2013 is definitely after 2009. Again, this order in question, Your Lordship, from when I have been given this replacement pay scale, Lordship, it is dated 2000, second SFU, Lordship, which they call SFU.
Yes.
It has been given in 2013. So, Lordship, it is governed by MACP. MACP says, Lordship, 10 years, 20 years, 30 years I am entitled. So if I am to get anything under MACP, first time, Lordship, should be after 10 years from my joining, 88, 99. But this is given in 2013 with effect from 2008. It is clearly MACP, Your Lordship. It cannot be under ACP. But Lordship, if Your Lordship is pleased to turn to that notification, that Your Lordship is at page in my amended writ petition, Lordship, it is at page 50A, 59A is the typed copy, Lordship. This is under ACP.
Yes.
Lordship, your Lordship will find this at page 58, first para. The notification, the order accompanying this. First, this is order dated 20th December 2013, Lordship, page 58. Just one page ahead.
Yes.
Lordship, it clearly says, under the provision of the UGC letter number so-and-so, as approved by Executive Council in its meeting dated so-and-so, resolution number so-and-so, and in pursuance of the recommendation of the screening committee held on 16/12/13, the Vice Chancellor is pleased to grant financial upgradation under the Assured Career Progression Scheme, ACP. 2013 ACP is not there, Lordship. MACP has come in. Lot of water has flowed. ACP is not in operation then. In 2013, they can give me under MACP, Lordship. If they have to give me under MACP, they have to give me after 10 years, 20 years, 30 years. So by their own showing, Lordship, what have they given me in 96? Because 96, I have not completed 10 years. No. 96, Lordship, I have not completed 10 years. One is, I don't get autumn because I have not completed 8 years. But I also have not completed 10 years, so they could not have given me that upgradation under ACP. So what was that? That was only a replacement pay scale, Lordship. And this is my first upgradation, which they call second, but this is actually first. And why it is wrong is, Lordship, because they have given in 13 with effect from 2008. MACP's simple calculation 10, 20, 30 years, 88, 99. This should be with retrospective effect from 99. That's my case, Your Lordship. And the second one should be in 2009. The third one, they don't dispute, they will give me, Lordship, as soon as they say the matter is no longer sub judice. That's my limited case, Your Lordship. Deeply obliged, Lordship.
Certain clarification here. Yes. I need to clarify certain confusion, huge confusion. Lordship will come back to my additional affidavit. Additional affidavit, page 53, annexure 1.
Your additional affidavit dated?
My additional affidavit. My additional affidavit dated March 19. Lordship has got
19.
Yeah, March 19.
Yes.
Now, Lordship will recollect what I submitted, my lord. The replacement pay scale as per Part A, which only we can follow, nothing else, as per the instruction of the Ministry of Finance, my lord, we have granted him. Now, he was filing representation, he said under OTUM, he is entitled for the next higher grade. Now that was considered, my lord, I will not take the trouble, Lordship has already noted down.
Yes.
That was considered, and exactly when he completed, my lord, 8 years of service, he completed 8 years of service sometime in 97. I have relied on that chart. With effect from 97, he was granted OTUF. But he was still not happy. In his representation, he said, I am not happy with this. Place me in a higher scale. The language he used, higher scale. What is that higher scale? 5,500 to 9,000. Now, in this situation, my lord, as I have stated, we formed a anomalous committee. But they have a problem with other staffs also. Anomalous committee was formed by the EC. And they said, look into the pros and cons and make your suggestion. Now, what is the job of a committee? They look into, explore, they don't take a decision. They made suggestion, they made recommendation. It is for the authority to take a decision. Now, my lord, decision taken by that anomalous committee, that was placed before the 109 Executive Council meeting. Now, my lord, what is the function of an Executive Council meeting? Executive Council is the highest in taking executive action. They are an authority. Nobody, BC, no other official can override that. They are the supreme, your lordship. Now, lordship, come to page 53, annexure 1. Annexure I think. Lordship has got it.
Annexure I.
53.
Yes.
Annexure I.
Yes.
Northeastern Hills minus 109th meeting of the executive, dated 4th, 2001. 4th April 2001. Next page.
Yes.
Now, this was placed before the EC. Now, they are the most competent authority to take a decision. Now, what decision they had taken on the top?
Yes.
The council considered the recommendation of the pay anomalous committee appointed by the university and resolved to refer the matter to a committee consisting of the following, and chairman was authorized to take action on the committee's recommendation. Now, what, my lord, this is very important, you need to understand this. Now, what the EC did not take a decision. EC instead constituted a core committee, a smaller committee comprised of register, finance officer and internal auditors. And they said, these committee will further look into whatever report submitted by the pay anomalies committee and further authorize, lordship will say, instead of EC taking a decision of its own, it authorized the chairman. That is the vice chancellor. Vice chancellor, while I am coming to it. Now, matter ends there. Now, here she has created the confusion. Let's see, lordship will come to the, my lord, annexure J. My lord, these I have annexed only for this limited purpose. The EC taken a decision, refer to a core committee, authorize the VC to take a final decision. Now come to lordship annexure J. This is nothing to, this is not a decision of the executive committee. Lordship will read the heading, minutes, my lord has got it, 56. Yes. Minutes of the meeting of the subcommittee constituted by the executive council such and such. This is, EC has nothing to do. This is not a decision of the EC. This is the minutes of the subcommittee, your lordships. And the next page, I had read it already, 57. Now, 57, they are clearly referring, my lord, 57, your lordship got it? Yes, yes. Third paragraph, small one line. The executive council consider all the items and resolve to refer the items to the committee. This is, they are referring to earlier decision of the EC, by which this committee has been constituted and the pay anomalies committee's report has been referred to. This is not a decision, my lord. These are the minutes of the executive committee. No, sorry, my lord, minutes of the subcommittees. Yes. It's not of executive committees. And ultimately, what decision they have taken, my lord, at 60? That is again, my London friend passed on EC. This is not a decision of the EC, my lord. This is a recommendation, suggestion, whatever, by the subcommittee. This is a decision of the subcommittee. EC is not associated.
But whatever the case may be, the final decision is of the BC.
Exactly. Now, my lord, as per the EC, authorized the BC. Now, BC has taken a final decision. Obviously, BC could not have acceded to this. They are saying you adopt a scale means for some other ministry. We could not have done. There are various ministries with various pay scales because we have to confine. So BC realized it, then BC granted it as a higher pay scale. He has categorically mentioned OTM will not give you, obviously there is no question, because we are giving you 2 quantum jump, higher pay scale, so nothing more. So my lord, lordship, I will not trouble my lord, those repeated letter of the UGCs, they categorically say C2 promotion, any financial upgradation, what they say, any financial, forget about other thing OTM. They have mentioned OTM or any financial. So, lordship, if it is not coming within the scheme of OTM, obviously it is not. It is not with C2 promotion. But obviously, any financial upgradation, it will fit into it. So, if any financial upgradation, that is to be adjusted. You got 2 quantum jump. So, that is the first. And that being the first, my lord, second we have given. Now my learned friend is saying one thing I could not understand. In 2013, already MSCP was holding the field. Then why you consider my case under SCP? Now my lord, I have referred to UGC's letter. Categorically they spelled out that UGC hold field till 31st August 2008. And MSCP from 1st September 2008. So all the eligible cases, my lord, which had ripened before that deadline, 31st August 2008, had to be considered under SCP. Now, this is a very simple case, your lordship, simple equation. Now, we have granted financial upgradation with effect from 1/196. Now, under SCP, after another 12 years from the first. So, my lord, if we count the second financial upgradation at 12 years from 2006 and 1996, it falls in 2008. So 2008 MSCP was not there, though it was considered in 2013. But since he was eligible from 2008, we granted him under SCP. Now, of course, the third, if it is not given, that has to be considered after 10 years. What my learned friend is trying to project that SCP under 12 and 24 hours, my lord, once a benefit is given under any other scheme, and even without scheme, any financial upgradation, that has to be adjusted against SCP, against MSCP. So, my lord, this is a case, do not call for any interference.
Lordship, though we've given one written, like bullet points, your Lordship, now after this hearing, if your Lordship allows us, what we have argued in the form of points, we may be allowed to place, and also the judgment which we have given, Lordship, because it's a very lengthy judgment, we're referring to only certain paras, so that has not been indicated. So in this fresh one, we'll just indicate and exit, your Lordship.
So you do it.
My lord, only thing, this is for lordship, you convinced. I am very sorry, your lordship, because earlier occasion, I don't know how it happened. Lordship has asked me to file a synopsis. But I don't think, my lord, we have done it. It's run into 13, 14 pages, my lord. Instead of helping your lordship, I think I am troubling your lordship. I should not have done that. I have prepared a small synopsis. This is running into 4.5 pages with reference to all the relevant documents and all. I'm just submitting it.
Lordship, similarly, we'll place like one page.
But that one, lordship can note, my lord. There are two, I think, two different points of time. These are running into 13, 14 pages here, longer than the writ petition. So lordship can note down, my lord. Lordship will discard that.
Okay.
And one I am filing today. I am filing it today, lordship. This is only 4.5 page.
Deeply.
Give a.
Lordship will give it tomorrow.
No, give her a copy.
I'm just giving. I'll give her a copy. Just give her.
So tomorrow.
Lordship, 2 days, day after morning.
Lordship. Obliged, madam.
Deeply obliged, Lordship.
Heard learned counsel for the parties. Hearing concluded. On premier by the parties. Synopsis of the written of the argument is allowed to be filed. The same to be allowed to be filed on the next date.
We are filing.
List this matter on 20.
We are filing it now. It's ready.
No, she can see it.
No, she will file. No, we are filing. This
Once you're filed, it will be on record.
Obliged, Lordship. Deeply obliged.
But only, by chance, I don't know, is SKP or lordship knowledge, because there are two, I think, synopses. Those can be discarded.
Lordship, regarding this other connected matters, if your Lordship is pleased to indicate when it will be taken up.
My lord, I will pray, my lord, decide this. Then it can. If your lordship
I have
feels
no
different,
objection, Lordship. Let this be decided and then the others will be taken up. Deeply obliged.
We'll just post this matter after 2 weeks and then we'll see.
Deeply obliged, Lordship.
But I don't think I'll be able to finish this session.
No, it's all right, no problem.
But
I don't think, my lord.
so when you see this,
only lordship, this matter is coming again and again. So
yes, so I think
so we have concluded your lordship. Now it's for your lordship, my lord.
Today should be the.
We have taken up a lot of time of your Lordship. We're grateful, Lordship.
Grateful. Lordship has given us a very patient hearing.
Deeply obliged.
All of us are equally to be blamed. No, Kitikwi matter. List this matter after 3 weeks.
Deeply obliged.
Obliged.
So.